My lord, may I make a urgent mention, my lord? Matter relates to a vending association, my lord, of Moriani Railways. My lord, authorities have given us a closure notice to close our vending units by 31st October. That is day after tomorrow, my lord. So I pray tomorrow,
Tomorrow.
my lord. Deeply obliged, my lord.
May I please, your lordship? Lordship, I beg to mention item number 26, lordship. There is some difficulties, lordship, today.
26.
Yes, lordship.
Yes, you are for?
A Kalita. For Industries and Commerce Department.
Okay. What is your prayer?
Lordship, he's having some difficulties, lordship, today.
They have informed the other side.
Yes, lordship.
Anybody present? Okay, Mr.
N Kalita, lordship.
and Kolita representing Mr. Land Council, representing Mr. A. Kolita, Land Standing Council, Industries and Commerce Department, comma, with the consent of the Land Council for the petitioner and the other sides, other respondents, comma, has made a prayer for adjournment
Lordship,
on
we
the
have
ground
2
that
weeks,
Mr. Kolita has some personal difficulty today. When?
after 2 weeks, lordship.
Okay, as prayed for, it is the case after 2 weeks.
Obliged.
May I please, your lordship? I beg to mention item number 21. Maybe adjourned for the day, lordship.
Okay, on the prayer of Ms.
Ms. D. Bora, on behalf of Mr. M.U. Mahmood, for the petitioner.
Ibora, allow me Mohammed Land Council for the petitioner. The case is passed for the day. It is submitted that consent has been taken. You have informed our sides.
No, lordship. I'll
Huh?
inform them. I'll inform them, lordship.
Okay. No, consent has been taken. Very good.
Lordship, I beg to mention for listing of a writ petition matter pertaining to land acquisition of a landed property.
Land acquisition. Maybe first week of,
Lordship, on 7th.
not 7th. After that week. Admission column.
May I please, lordship, my lord, I beg to mention for listing, my lord.
Hmm.
Pending cases, it is last listed, my lord, in the month of
What is
March.
subject matter?
Subject matter, my lord, the private government road, my lord. Petitioner encroach the government road, my lord, which creates, my lord, the
Okay. Next week or day, but next week.
obliged, my. No, please, your lordships. I beg to mention for item number 20, lordships.
20.
Lordship.
Yes.
May be taken after 3 weeks, lordship. The consent has been taken from the petitioner's side, lordship.
Okay. You are appearing for whom?
I am appearing on behalf of Mr. J.K. Goswami, Standing Council, AIDC.
AIDC.
Lordship.
Your name?
Mr. J. Borman, lordship.
Mr. J.
Borman.
Borman, Learned Council, on appearing on behalf of Mr. J.K. Goswami, Learned Standing Council, AIDC, for the respondent number 3 and 4, has prayed for adjournment of the case by 3 weeks. It is submitted that consent has been MS. Okay, as now Learned Council for the petitioner who is in attendance, comma, has submitted that the petition side has consent to the safe prayer. And we have the above list the case after 3 weeks. Only did 2 weeks by the office. Yes.
Item number 24 and 25, my lord. Can it be taken next Tuesday, my lord? Because
Okay.
the NCB has cited many case laws. I have to go through them.
Okay. On the prayer of Mr. Anand, Learned Council for the petitioner, Thursday? Thursday. This is the cases on Thursday, 24 and 25. And it is submitted that consent has been taken from the Learned Standing Council, NCB, to make the prayer.
Ali obliged.
7-11. May I please, your lordship? I beg to mention for item number 19. Okay?
19.
Learned Arguing Council informed me over telephone that he is out of station. Okay?
You are
Kindly maybe fix up
for the petitioner?
petition.
You have informed many private respondents. Okay, we will not call it.
Obliged.
May I please?
Yes,
My lord, item number, my lord, 23, my lord.
23.
Yes, my lord, we have been instructed to do the case with the liberty to approach before the appropriate forum, if so advised, my lord.
Mr. M.U. Mondal, learned counsel for the petitioner has submitted on instruction, he has instruction to withdraw. The petitioner wants to withdraw the writ petition with the liberty to approach, in order to approach the appropriate forum to seek relief. Okay, Mr. R. Goswami, be informed.
My lord.
R. Goswami. Mr. Mondal has submitted that he would inform Mr. R. Goswami, learned counsel for the respondent. So, in view of the above submission made by Mr. Mondal, learned counsel for the petitioner, the writ petition is dismissed on withdrawal, reserving the liberty to the petitioner to approach the appropriate forum in order to seek relief.
Deep law, please.
For motion, item number 22. May it please your lordship. Regarding that manner freezing of my bank account,
Mhm.
on that day they have submitted a report, your lordship. They have cited 3 grounds, my lord.
Mr. Goswami, you file a short affidavit on this basis. We'll keep it in motion stage itself. Within 7 days. Heard Mr. S. M. Abdullah, learned counsel for the petitioner, and Mr. N. Goswami, learned junior government advocate, representing the respondent number 1, 2, and 3. Any other respondent?
Those are just in titular.
Branch manager is GFC. I think Mr. PJ Bhukan is standing counsel Guwahati University.
On the last occasion, he was there, my lord, but he is in the titular.
Oh, he's there. Okay, he's there. Okay. This, can you serve it by the notice? Will respond number 4?
Lordship, we can, no problem.
Okay, then we'll put it on other respondents are represented.
Only 4.
Okay, then 13th of November.
13th of November.
The respondent number 5 is also represented by the Land Standing Council, Guwahati University. First off, issue notice returnable on 13 as Mr. Goswami and Mr. PJ Phukan. Represented by Mr. PJ Phukan, Land Standing Council, Guwahati. Has appeared accepted notice on behalf of the respondent number 1 to 3 and respondent number 5 respectively. Issuance of formal notice and dismissed with petitioner shall take steps for service of notice upon the respondent number 4 by registered post with AD. In addition, as preferred by the learned counsel for the petitioner, the petition is permitted to take steps for service of notice upon the respondent number 4 by way of the compliance affidavit 2 weeks. We file a compliance affidavit. Lays the case on 13/11/2024. Most of the respondents, Mr. Goswami, learned counsel for the respondent number so-and-so, junior government advocate appearing for respondent number so-and-so, has submitted that he will file an affidavit on the basis of the instruction status report received from the respondent number.
Investigating officer.
Respondent number 2 to 3, 2 and 3. On or before the next date of listing. Full stop. It is observed that the writ petition will be taken up. Endeavor will be made to take up the writ petition for final consideration.
Oblige you, Lord.
Item number 1 for admission.
With your lordship. My lord, this matter relates to threatened eviction by the railways from the, my lord, the patta land of the petitioners.
Patta land of the petitioner.
In fact, my lord, the
Eviction or threatened?
threatened eviction, my lord. In fact, my lord, affidavits have been exchanged, your lordship may like to take up for final disposal, my lord.
It is up to you. Parties are ready. We can take up the matter.
Now, my lord, the petitioners, my lord, their prayer is that, my lord, the contemplated action of the respondents, if prayers your lordship will may kindly
Okay.
speak. At page 26. Declaring the proposed and contemplated action of the respondents, more particularly the respondent number 1 and 2, my lord, they are the railways, to evict the petitioners and to demolish their building situated in Dag number 13 of Patta number 109 of village North Jalukbari, Moja Jalukbari in the district of Kamrup as illegal, null and void, with direction to allow the petitioners to live peacefully in the respective houses standing over the said land. Then, my lord, a prohibition the respondents from carrying out an eviction drive against the petitioners. So these are the prayers. So what happened, my lord? The petitioners, they have purchased the land. These are patta land. All the, my lord, documents, their sale deeds are annexed, my lord. That is why the petition is a little voluminous.
Okay. Register silly.
All are registered sale deeds. They are from, my lord, some of them purchased in 1999, then subsequently, then 95, 2007, my lord, up to page 242. These are all, my lord, sale deeds. And these sale deeds are, my lord, not disputed by any of the, my lord, respondents. The railways have filed their affidavit. The deputy commissioner has also filed the affidavit. So these are, my lord, not disputed. And we have prepared a chart at annexure 2, my lord, page 243, containing the, my lord, respective areas of the petitioners, dates of the sale deeds, and name of the sellers.
What is the total area?
Total area of the land, my lord, that the petitioner.
In the prayer, it is said that 8 bigha something.
My lord.
In the prayer,
My lord.
in the prayer, what is the? Eight bigha, 1 kata, 14 lesser.
My lord.
So 243, 244,
These are, my lord.
fifth column, area of land.
Yes, my lord.
So total comes to 8 bigha,
Yes, my lord.
1 kata. Mr. Vardas? Fifth column, area of land.
Area of land, my lord, we have.
There appears, how many? 30,
31.
how many petitioner? Family?
31, my lord.
31.
My lord.
So total comes to 8 bigha.
Yes, my lord, but we have not added here.
Should have been,
Indeed,
should have
sir.
added,
True, true.
not leaving to the
Yes.
court to calculate. Yes.
We just
Mr.
help-
Borders, you do the exercise.
In the meantime, we'll let him do the exercise. Now, page 246, your lordship will find the mutation orders in my lord draft status certificates have been issued by the assistant settlement officer.
Mutation orders.
My lord, these are the certificates of the assistant settlement officer regarding the mutation. Page 246. These are all not disputed, my lord. But I am drawing your lordship attention, my lord, to show that, my lord, they are the bona fide owners of the plot of land. And they have
constructed houses after
নথি
taking.
বর্তমানে প্রস্তুত করা নোয়াট ফাইনাল ড্রাফট was not prepared.
No, my lord, no. that was
So
not-
these are the certificates.
Yes, my lord. And 200 page, 240
So what this mutation is called, mutation in draft
Sita mutation, my lord.
Sita mutation. Okay, these are up to page
Up to page 259.
259. Maybe more. Maybe more.
No, my lord, from page 260, that is annexure 4, these are the, my lord's certified copy of the Jamabandis of the particular patta.
Annexure 4. No,
Annexure
annexure
4,
4.
page 260 onwards, my lord.
Annexure 4. Annexure 4 starts from
Sorry, my lord,
266.
266, my lord. The 6 has been, my lord,
Yes,
0 has been, 6 is 0, my lord.
266.
My lord.
Annexure 4. These are Jamamandi incorporating the mutation details.
Yes, my lord, in respect of patta number 109. Here's periodic patta number 109.
So we are concerned with patta number 109, dag number 13.
Right.
Yes.
Now, what happened, my lord? There was a notice issued to the, my lord, the patta holders, not only the petitioners, the others, my lord. In that, my lord, patta, there was a notice issued by the, my lord, deputy commissioner. Asked them to, my lord, produce the records of their ownership and title, my lord. Then, my lord, they appeared before the deputy commissioner. Those documents are, my lord, since.
Where you have stated in the petition?
Your lordship will kindly see the document at page 270.
200 and
270.
deputy commissioner. By the memo and the reference, 24 persons were asked to appear before your good sir to participate in the hearing over the disputed land situated village and so on, so and so. When the signatory appeared before your good sir were asked to signatory was briefed enough to take up the hearing patiently over the land pertaining to so and so. Sale deed, mutation, house, organization, position, future further, after obtaining the permission for now. Okay.
So, my lord, though they have appeared and shown their documents, but no order has been passed. My lord, the matter registered thus, that was in, my lord, 2010. Then what happened, my lord? These petitioners and, my lord, some other persons, my lord, of the same patta, they were also issued with the notice. They also appeared. Since, my lord, no order was passed and there was an attempt to, my lord, evict the petitioners and the others, some of the, my lord, persons in that patta number, my lord, they had filed a civil suit.
Other than the petitioners?
Yes. They had filed a civil suit. The plaint I have annexed, my lord, at page 271.
These are not the petitioners.
These are not the petitions. Some, my lord, I think 3 or 4 petitioners, present petitioners were also there because, my lord, their land was also there in the other part of the, my lord, that patta. Some of them, my lord, 4 or 5.
Okay.
So not in this, my lord, that 13 biga. So they filed a suit for declaration of right title and interest, confirmation of possession, and injunction restraining the railways from eviction. So, my
What
lord,
was the area of land involved there?
my lord, that your lordship.
Schedule?
The plaint,
Schedule is there.
yes, my lord, schedule is there. Yeah. Please, 200.
What is the total area? 4 biga? Trilesa?
My lord, the plaint
284?
284 is the, my lord, prayer.
There, Mr. Bhordas has done the calculation perhaps.
Yes, my lord, he is just calculating that.
Page 284, after the table, 4 biga in pencil, Trilesa,
Yes, my lord,
284.
my lord. And
Is it correct, Mr. Bhordas?
Okay.
Okay, title suit.
The title suit was filed.
Hmm.
Then
That
my
was
lord-
in 1999.
Yes, my lord, title suit 100 of 1999,
Okay.
and the my lord suit was decreed.
Hmm.
The decree, your lordship will find at page, the judgment. is
I think
decree-
4 bigger 3 lesser, page 287.
Yes, my lord.
Hmm.
Judgment, your lordship finds at page 280
Ex parte,
286.
ex parte.
No, my lord,
It appears
expert-
paragraph
no,
3.
Expert against my lord, some of the defendants, private defendants, not against the railways. They have contested, they have filed their written statement.
Okay.
Your
Regular
lordship will
contested.
kindly come to page 200.
Now, who is defendant number 1 and 2?
1 and 2 is the railways.
Railway is represented by whom? It's about
But in this case,
Ah. 1 and
page
2. Okay.
287,
Okay.
paragraph 3, my lord, of the judgment, your lordship will find that.
Sin.
Serial number, paragraph number 3.
Okay.
The defendants number 1 and 2 appeared in the suit and contested the case of the plaintiffs.
Hmm.
The suit proceeded ex parte against defendants number 3 to 39. So they were my lord, private parties. My lord.
Hmm.
In their written statement, the defendant number 2 and 3 denied the claim of the plaintiffs and stated that the suit land belonged to railways, as the same was acquired by the railways in the year 1959. So this was the stand of the railways before the my lord civil suit.
Just a query, why some of the petitioners had filed this title suit for some of the portions of their land, leaving aside,
Yes, my lord.
what is the reason?
Yeah, reason is that, my lord, that they had land in, my lord, the other part of the the same patta number, my lord. So they joined, my lord,
In other ducts.
other ducks, not this duck number 13.
Not in duct number.
13.
Duct number is what? 13.
13, my lord. So
Duct number is 13.
my lord.
Thirteen is not included here. 13 is there, page 287.
My lord, they got specifically, my lord, the portion of the land they were, my lord, occupying, and my lord, they had purchased.
Because come to 287, second line, duct number 13 is there.
Duck number 13 is there, my lord.
Hmm.
So some of them, my lord, they had, my lord, mobilized and filed the case, and some were left out. In fact, my lord, all of them could have filed the suit together.
Hmm. Yes.
What happens on the land, your worship will, my lord, notice the land is between the, my lord, Paraigarh Bridge and the, my lord, the highway. I mean, the main road.
Hmm.
And my lord, the land which were by the side of the road, those were, my lord, primarily threatened to be evicted, and that's why, my lord, those persons immediately filed the suit.
Okay.
So stand of the railways in the suit is that, my lord, this was acquired for the railways in 1959. Your worship.
Where is that?
That in paragraph, page
Paragraph?
paragraph 3, my lord,
Paragraph
of the
3
plaint,
of the
of the judgment, my lord, at page
Judgment.
287. Defendant number 1 and 2 appeared in the suit and contested the case of the plaintiff. The suit proceeded ex parte against the defendant number 3 to 39. In the written statement, defendant number 2 and 3 denied the claim of the plaintiffs and stated that the suit land belongs to the railways, as the same was acquired by the railways in 1959. Your lordship will remember, my lord, this bridge, my lord, the original Paraigarh Bridge was, my lord, constructed in 1960 and was completed in 1962. And my lord, their claim is that in 1959, my lord, that was acquired. And I'll show from the, my lord, affidavit filed by the railways that, my lord, from 1959 till 2017, my lord, they were not really doing anything. Now, my lord, this suit has been decreed. Then, my lord, they filed an appeal. The railways, my lord, filed an appeal. And the appeal was, my lord, dismissed on the ground of perhaps, my lord, delay and the restoration of the title suit appeal, my lord, that was rejected at page 300, your lordship will find that order,
Page 300.
300.
Before the district judge.
This is before this civil judge senior division, my lord.
Okay. It was decreed by whom?
Page 300, my lord, in the court of
No,
civil judge.
no, original suit was decreed by
So Munsif, my civil judge junior, my.
Civil Judge Junior Division number 3. Okay. Procedure representative is arising out of petition by the Indian Sir. 150 paper restoration readmission of miscase number arising out of so on the grounds. Okay, order 9, rule 9, rule
Right.
13. Hmm.
The next
Then what
page-
is 301?
Page 301 is the order, my lord, the application for condonation of delay.
18.3.
Application for condonation of delay, 301. Both
Okay,
were
this is
rejected,
called delay.
my lord,
Earlier on was restoration.
my lord. So both are rejected by the,
Okay.
my lord, civil judge senior.
Which paragraph you have stated here? Stop going.
In the pleading, my lord,
In the writ petition?
these are also not in dispute, my lord.
No, no. If I have to record without going through,
Yes, my lord.
I am trying to find out. Okay, paragraph 12.
5, 6, 7, 9, and 10.
Paragraph 12.
Paragraph 12, my lord. Yes,
This is the description
yes, my lord.
regarding appeal.
Yes, my lord.
Okay.
That against that, my lord, the railways approached this honorable court by
Hmm.
filing a revision petition, and that was allowed, my lord.
That was allowed.
That was allowed.
Hmm.
Said that this honorable court said that you hear the petitions on merit.
Okay.
That was the order passed. That your lordship finds at page 302.
Hmm. 302.
That is an order of my lord.
The
29.
impugn order so and so have a set aside and direct to hear the miscase on merit.
Merit.
On merit.
Thereafter,
So
my lord-
otherwise it was technicality.
yes,
Restoration was on technicality, order 9, rule 9
yes,
or rule 13.
yes.
Okay.
And also, my lord, delay was not properly explained.
Okay.
Then your lordship may kindly come to page 310.
Hmm.
The civil judge, my lord, the learned civil judge, then again, my lord, after hearing the matter on merit, page 310, order dated 15/5/2010.
Hmm.
My lord, the trial court, my lord, rejected this, both this, my lord, these cases.
Hmm.
So, my lord, this order, my lord, gave a quietus to the, my lord, civil suit.
Okay.
Now, what happened, my lord? This is
Hmm.
of 2010. Thereafter, my lord, in 2017, there was again a move, my lord, to evict the petitioners and the others. And my lord, the petitioners have filed this writ petition in 2017. The other persons, my lord, who had the decree in your favor, in their favor, they had also filed, my lord, the writ petition.
Okay.
And in fact, my lord, that writ petition has been allowed. That order your worship will get in the affidavit in opposition. Of the, my
This is
lord,
the repetition.
the other,
314
the other petition. Yes, my lord.
are those who had the decree.
Those who have the decree. That your lordship will find at page 331, that is a part of the affidavit filed by the, my lord, respondent number 4. the deputy commissioner,
300.
331.
Three hundred thirty-one.
My lord,
What is that? 331?
that is the, my lord, the judgment of this honorable court in the other WPC 1553 of 2017.
Oh, no, 331.
My lord, that is what the my lord serial number, page number that has been
Oh, yes, and
Okay.
annexed as annexer
4
to the affidavit of position of
of the deputy commissioner.
deputy
My
commissioner.
lord.
Deputy commissioner. Deputy commissioner, response number 4,
Yes, my lord.
annexer 4.
Annex of 4 months. Has your lordship got it, my lord?
Hmm.
Has your lordship got it? my
Hmm.
lord? If your lordship permits me, I'd like to read the entire judgment because, my lord, the facts are same, except that, my lord, these persons approached the civil court and we did not. That's why, my lord, if your lordship permits, my lord, I'll to read the judgment. The instant writ petition has been filed by the petitioner seeking a direction upon the respondents, more particularly the respondents number 1 and 2, that is the railways, not to evict them and to demolish the buildings situated in Dag number 13 of KP Patna number 109 of village so-and-so, Jalukbari. The facts as can be discernible from the materials on record reveals that the petitioners as well as the predecessors in interest have jointly filed a suit, being titled suit number 199 against the Union of India represented by the General Manager, North-East Frontier Railway, seeking a declaration that the plaintiffs are the owners and co-possessors of the land shown in Schedule A and for confirmation of possession over the said land. The plaintiffs in the said suit also sought for a permanent injunction restraining the principal defendants, that is the respondents number 1 and 2 herein, and their agents from evicting the plaintiff from the suit land. The court finds it relevant at this stage to mention that the suit land in question, at measuring 4 bigha 0 katha 3 lectures, covered by Dag number old 13, new 581, 582, 583, 584, 585, 586, 54, 55, 43, so and so in NK Patta number 1, new 7891 and 13 of village North Jalukbari in the district of Kamrup in Moja Jalukbari under the police station Jalukbari in the district of Kamrup. The record further reveals that the said suit, being titled suit number 199, was decreed in favor of the plaintiffs by the Court of the Civil Judge, Junior Division number 3, thereby declaring the right title and interest of the plaintiffs over the suit land. The possession of the plaintiffs were also confirmed over the suit land, and also a permanent injunction was passed against the defendants number 1 and 2, who are the respondents number 1 and 2 herein, restraining them, their agents, servants, etc., from interfering with the principal possession over the suit land, from demolishing the houses constructed over the suit land, and from evicting the plaintiffs from the suit land. The said judgment and decree dated 24/1/2001, passed in title suit number 199, was challenged in appeal before the Court of the Civil Judge number 2, along with the condonation application. The said appeal was registered as title appeal number 78 of 2001 on the ground of delay. The said appeal was also dismissed. It is therefore the case of the petitioners that the respondents, more particularly the respondents number 1 and 2, cannot evict the petitioners in respect of the said plot of land measuring 4 bigha 0 katha 3 lectures covered by NK Patta number 1 old, new 7891 and 3 in Dag number old 13, new 581, 582, etc. of village North Jalukbari under Jalukbari Moja in the district of Kamrup Metro. It is further case of the petitioner that they came to learn that the respondents number 1 and 2 were proposing to evict the petitioners from the land for which the instant writ petition was filed. The record reveals that the court, by order that is 17/3/2017, issued notice, and in the interim provided that the entry number Gh dated 3/12/2009 in the Jamabandi of KP Patta number 109 of North Jalukbari shall remain stayed. The record further reveals that an affidavit in opposition was filed by the respondents number 1 and 2. In the said affidavit file, it was mentioned that the railways acquired 203 bighas, 2 kathas, 12 acres of land from Brahmaputra Beach project at Pandu area, South Approach Project 1 and 11B in the year 1959. It was further mentioned that the land measuring 47 bigha, 0 kathas, 16 lechas out of the total land of 60 bighas, 2 kathas, 7 lechas of land covered by Dag number 13 of NK Patta number 1, old, KP Patta number 109 new of the revenue village North Jalukbari, Moja Jalukbari under Revenue Circle Guwahati in the district of Kamrup was acquired by the Revenue Department, Government of Assam and allotted to the railways, and 13 bigha, 1 katha, 13 lessas remained as patta land, which is apparent from the record. It was further mentioned that a letter dated 3/8/2017 was written by the NF Railway Authority to the Deputy Commissioner Kamrup for demarcation of the railway land from Dunlop Bridge, Jalukbari to Brahmaputra Bridge, Horaighat Bridge, South Approach at the earliest. In response to the said communication, the additional Deputy Commissioner Kamrup, Guwahati, Assam, wrote to the circle officer to take necessary action. This is my lord in 2017. In the said affidavit, more particularly, may I read? Paragraph 9, I am reading. In the said affidavit, more particularly at paragraph number 8, the respondent duly admitted to the passing of the judgment and decree dated so-and-so entitled so-and-so in respect of the land measuring 4 bigha, 3 katha, lessas covered by NK Patta number old so-and-so of village North Jalukbari under Jalukbari Moja in the district of Kamrup Metro. Further to that, at paragraph 12, it has been mentioned that the railway initiates eviction proceeding only against unauthorized occupants of railway land in strict compliance of the provisions of section 4 and 5 of the Public Premises Eviction Act 1971. I have heard so-and-so, para 11. These are the findings, my lord. From a perusal of the materials on record, one aspect is clear that in respect of the old of the plot of land measuring 4 bighas, 0 katha, 3 lechas covered by NK Patta number 1, old 7 new, 8913, Dag number 13 old, and my lord, new Dag's number have been given of village North Jalukbari under Jalukbari Moja in the district of Kamrup. There is a decree passed in favor of the plaintiffs of the said suit are either the petitioners or their predecessor in interest, thereby declaring the right, title and interest as well as possession of the plaintiffs and also issuing a permanent injunction against the respondent number 1 and 2 herein not to interfere with the possession. Under such circumstances, unless and until the decree passed in TS number 100 of 99 is not set aside, the respondent number 1 and 2 cannot interfere with the possession of the
Basically, this petition is based on that decree.
Yes, my lord. Yes.
And at the last paragraph,
My lord.
following observation and direction, Roman 3,
In respect of the
1
other
and
land-
2 pertaining to those decree.
Yes.
Roman 3, in respect of
Of the
the
other
other land shall be at liberty
To take such action as permissible under
under the law. Now, what is their affidavit, stand in the affidavit?
of the railways, my lord.
Yes.
The railways affidavit, my lord, I'd like to point out, my lord, that suffers from the vice of, my lord, non-traverse. Many statements which have been made in the, my lord, writ petition, those are, my lord, not touched by them. The affidavit in opposition, your lordship will find, it starts at perhaps, my lord, page 341.
Engineering 60 began.
Has your lordship got it, my lord? Your lordship may come to straight to paragraph 5 at page 342. The stand of the railways. May I read it, madam? That with regard to the statements made in paragraph 4 of the writ petition, it is stated that as per record, railways acquired 203 bighas, 2 kathas and 12 acres of land for Brahmaputra Bridge project at Pandu area, South Approach Project 1 and 11B in the year 1959. which is evident from the correspondence by the then Lane Acquisition Officer Guwahati with the Government of Assam, Revenue Department and various concerned authorities.
Hmm.
So this is the, my lord, communication of 1960,
Which one?
that my lord,
Hmm.
correspondence by the Land Acquisition Officer to the my lord railways that your lordship will find, my
Inviting
lord.
reference to the office letter, dated so and so address to the so and so.
Annexer R1, that is at page 348. They are speaking about this
Informally
communication.
taken over.
The communication your lordship will find at 348. This is of 1960.
Question is, was there any award? Any award they have mentioned?
No, my lord, they could
Huh?
have said, my lord, we have been given the, my lord, the land.
Award.
Have been, that is also not there, my lord.
Land deposit, requisition amount?
They do not say anything, my lord, from 1960 thereafter, my lord, in paragraph 6.
What money you have given as a requiring authority?
Lordship, if you see page number 349, they made an estimate of around 7,44,000.
Estimate is okay.
Actually, what has happened?
Okay, notification declaration is okay. Section 4, section 6 is okay. But thereafter you have to travel up to section 11.
Actually, most of the documents, my lord, are not available with the railways. That is the main.
And what does
problem.
the deputy commissioner say?
Now, my lord, so far,
Just a minute.
I'm sorry.
You know, very well, Lordship, that time has been
No,
recorded.
tell me award. Section 11. Section 11 award. Have you said anything?
The affidavit is-
Had the railway said that we had deposited the requisition estimate, and has the deputy commissioner has said that yes, we have passed an award under section 11 and disbursed the amount to the landowners, then all thing will be nullity.
True.
All other land deeds will be automatically nullity.
The affidavit, Lordship.
Now tell me, first question, then I will read. Money deposited, disbursed or not?
That were acquired by the.
No, acquires, everybody is saying, where is it? In our exhibit. See, the other is slightly distinct in the sense that they have a degree. Your affidavit.
Turning page 4, Lord.
Your affidavit by
Deputy Commissioner.
Deputy Commissioner means respond number 4. Yes, which part?
Turning page 4, Lord. First paragraph.
Paragraph
That is, 8. Third
8.
Page 4, Lordship.
Page 4, yes. What letter? This is some letter. Which letter? Belongs to 203 Vigga was acquired, according to the respondents, Mr. Chaudhary.
My lord.
And out of your village is
Jalukbari, my lord.
Jalukbari, Uttar Jalukbari.
Yes, my lord. Not Jalukbari.
105 Vigga, 1 Katha belongs to so and so. Required for construction of approach of the bridge by NF Railway. NF Railway. Okay. Required by PWD. Mr. Goswami, that letter is there of the Deputy Commissioner to the Revenue. It speaks about only Section 6 declaration.
Lordship, in my affidavit at running page number 12, my lord.
Your affidavit. Your affidavit. So,
Only one
Goswami, just.
document, my lord, I have
sure.
annexed
Huh?
that I have found, my lord, with the railways. The payment of
Page?
rupees 5 lakhs, my lord.
Huh? In annexer? Annexer? In your affidavit?
Lordship.
Which annexer? One dated?
Page 12, my lord. Dated the April of 1959, my lord. The date is not in.
Annexer.
Roll April. Right,
Authorize you to take advance position of the
So
student.
written to the Deputy Commissioner, Kamrut, my lord. Acquisition of land for construction of Brahmaputra Bridge project. The office letter to such and such, a pay order of rupees 5 lakh has been passed as lump sum deposit, which
estimate
in
of-
connection with the above are required to render necessary accounts of disbursement in due course.
Land given. Come to that before that. First, of the annexers,
But
you read the first one. Writing, I have the honor to inform you that for want of your sanction to the estimate cost to acquire 203 bighas in connection with construction of South Approach Road, I have not been able to dispose of the same. The land were informally taken over by
Given
so-and-so
given
on
whether to show
so-and-so
that
where
the-
notification and declaration were lately published and same were regularized after formal delivery of possession of the land 8/12/2015. This is written by land acquisition officer. It may be pointed out since we have not been marshalling land projects. Government have not, okay, 203 bighas.
Sure.
There was notification and declaration. Then come to next page. Please find enclosed herewith two estimates for acquisition. Estimate of Niskhiras, Kheras periodic patta comes to so and annual and Sarkari land so. The informal position has been given to you by the construction work started on the land, draft notification, declaration. The plan and certificate are sent to you by the for owner transmission to the secretary. You are requested to sanction the estimated amount. Sanction the estimated amount. Governor is pleased to authorize you to take advance position provided by so in respect of the so. After fulfilling the condition laid down in the executive instruction 96, pay order 5 lakh has been passed lump sum deposit.
These are only some documents which are available with the railways, my lord, to show that, my lord, 203 bighas of land were acquired for the railways, my lord. And most of the documents, it's not with us.
No, whatever.
The fact is that, my lord.
But award should have been there. Everybody speaks about section 4 and section 6. Nobody is speaking about section 11. And it is not, then it remains Patalan. It remains Patalan. Everything lapses. See, for the timing, is just an idea for me, subject to your, say, running page 327. The estimate for, these are all admittedly Patalans prior to some alleged acquisition. Alleged acquisition. Niskhiras and Khiras periodic patta comes to rupees 7,44,000. But you deposit only 5 lakh.
That's only part of it, my lord. Like I said, my lord, all the documents are not available with the railways.
No, where is the award? If no award, nothing. Everything is valueless. Everything is valueless. Show me. Then contention of the petition would be correct. Have you traversed that we have the award?
But the thing is, my lord, the.
And who are the
petitioners, they have
pattadars
acquired the
who have
land
been-
only in 99, my lord.
Huh?
Only in 99. That too, my lord, after converting the railway land into a patta
No,
land, my lord.
when they purchased the land, so whether in the revenue records they remained as patta lands. Patta lands, otherwise it would have been recorded as railway land.
If your lordship
Ah.
take up page. 350 or 266 of the writ petition, your lordship will see that this railway land was converted into patta land only in 1999, my lord. By one
That is
certain officer,
what-
my lord. Subsequently, my lord, in
That
2001.
is what I want to know.
understand
On what
officer-
basis? On what basis? Let us see,
That we
266.
do not know, my lord.
Oh, that cannot be an
My
answer.
lord, the revenue authorities can answer, my lord. How they have converted the railway land into patta land in 99, suddenly, my lord.
Let us see the order. As per order, Government of Assam.
My lord.
Do you have that order of Government of Assam? This is of 1999.
Lordship.
Is it part of the record? 8/4/1999 revenue?
And only in 89, my lord, after converting, they purchased the land, my lord. Suddenly, the
No, 18/4/19.
they come to know about this mistake.
No,
And they again reconvert,
firstly, you have to establish your right from the documents. It is not emerging that there is an award and disbursement of compensation to the pattadars. If no money has been disbursed to the pattadars erstwhile, the erstwhile owners of their patta land, first two things, award and compensation. Disbursement, these are important records. Otherwise, everything is valueless. All acquisition process, it lapses after 2 years. 1959, as per the LA Act, 1894, it lapses after 2 years. If the award is not passed,
Then the lordship will allow me some time, my lord.
no,
I just-
because the deputy commissioner, there is an exhaustive letter. I have just read, Mr. Goswami. I have just read one letter, but there is nothing. Next one. Other than declaration under section 6, 1894, there is nothing. That does not mean acquisition. So the erstwhile owner would remain owner and they would be having the right to sell. Am I clear? Other petitioners, they had a decree. So that attained finality. It goes. For example, they have not approached the civil court.
Civil court.
Now you are threatening them.
No, my lord.
That is what their case
The
is.
apprehension, my lord.
Huh?
The apprehension, my lord. We have not any
Whatever,
issued any notice, my lord,
whatever.
under Section 4 or 5
Whatever,
of the PPI.
if on the basis of what they have saying, if you can establish it is a railway land or by virtue of acquisition, then it will be Public Premises Act,
Lordship.
right? But show me the
We
award.
have written, my lord, in the affidavit also that we have not issued any notice for eviction.
No,
Till
first
date.
you have to get the right to issue notice under public premises, you have to be the owner in the real sense. Like a private party, the title is by virtue of sale deed. And for you, it is by virtue of an award. Right?
That is true.
Now, where is the award? Nobody is saying about the award. Is there any mention about the award?
No.
If the award, nothing, then 1959 land acquisition process, it lapsed. It lapsed. What is the period of lapsing? What is the period of lapsing in the other act, Mr. Chaudhary?
Years, my lord.
I think 2 years.
Yes, my lord.
Period within which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of publication or declaration. Now, your declaration is on 25/5/1959 from page 354, page 354. If no award is made within that period, the entire proceeding for the acquisition of the land shall lapse. So, if no award is passed before 25/5/1961, everything lapsed. The erstwhile owner had the right to sell the land to the petitioners. They, by virtue of the registered sale, did purchase it. End of the matter. That is the case.
My lord, that is all.
Without the award, you cannot say anything. Otherwise, other things are admittedly clear. They had DAG number
13.
13, 4 bigha something by
One.
virtue of the decree. And the other writ petition judgment says as permissible under the law. Now, to be permissible under the law, you have to be armed with an award under the 1959 land acquisition process. And section 6 declaration is in the year 1959. There cannot be any extension. And there is nothing on record that even after lapse, there was another land acquisition process. That is nothing. So only is that 59 to 1959.
The lordship will give me 2
60
weeks time, my lord, because one document is there that 5 lakh rupees has been paid, my lord.
No, I don't know. You have paid the amount to the
Deputy Commissioner.
Deputy Commissioner. That does not mean
That they have disbursed.
when it is vested. I think section 17 perhaps. Because I am considering this because of the prayer made in the relief sought in the writ petition. They are not seeking right and title. They are challenging your contemplated action of eviction. In a writ petition, they are not seeking right, title, and interest. Contemplated.
Were required for NFLA on payment of LA compensation.
Mr. Goswami, I think I have read the original one. Original letter from where you have quoted paragraph 4. Is it not? Then show me from that letter that you have paid money. You have paid money. Or your land is part of that 60 bigha.
Yes, ma'am.
60 bigha, I think out of 60 bigha, some 13 bighas
Were converted, my lord.
were converted to
Patta land, my lord.
Patta land. And out of the 13 bigha, that 4.
Yes.
And the remaining 8 bigha,
Yes.
that is your. That is their case. Now come to Mr. Goswami. Your that letter, paragraph 7.
Yes.
As per draft record of 1957 and 64, the status of the land covered by 178 old. Your one? 178 old?
No, old was my lord,
13, new 13,
new 13, my lord.
with an area of 60 bigha, 2 kata Samelasa was Niskhiras, meaning thereby it is Patta,
Half revenue, but patta.
half revenue, with clear Niskhiras boundary symbol printed on the map. During current Guwahati settlement operation, record has been corrected showing a plot of land measuring 13 bigha 1 kata as Khiras Miadi land, covered by DAG number 13 under KP Patta number 101. Your 101? 109. While the balance land of part Kho of DAG 13 measuring 47 bigha has been shown as railway acquired land. Mr. Borgotoki, then why you are interfering with that 13 bigha?
Because subsequently, my lord, we have written a letter to the deputy commissioner, my lord, that they have written to us stating that this 13 bigha is also railway land, my lord.
Where is that?
Your lordship.
Considering para 7.
Okay, let us read.
My lord, in my affidavit at running page
Since
21. my
okay,
lord.
just a minute. Rented and measuring. I want to know this one. Para 7, second paragraph. Your record. You cannot make something on supposition. Believe.
So I may be.
Belief. You get the record of award if any award is passed. On what basis he is saying to make such a responsible statement? Paragraph 7, second paragraph. He has to substantiate with record. Otherwise, everything lapses. And if there is no award, then petitioner is not liable to be evicted from their land.
That is one part, my lord, but otherwise, my lord, as per the documents they have provided to us, my lord, they said this 13 bigha is also railway land, my lord. They have written letter
They
to us, my
say,
lord.
where is that?
Pardon?
Where is the record award? First, I
Award.
have to be
That will
satisfied
not
with
give
the
us
award.
Time, my lord.
Otherwise, see, simple. If award is passed and erstwhile landowner had received their award, correction or non-correction of record would not imply much because they have lost the right to sell the land. Because after receipt of compensation, everything vested in the government. Power to take position, a correction. Power to take possession is 716. And I think there is a provision, everything vested in the government. Thereafter, no right to the erstwhile owner. Only this issue, otherwise they have made out a case. Considering that you are public organization. Is anything, Mr. Stewart?
The pertinent question your lordship has asked, my lord, if they can answer that, my lord, otherwise, my lord, perhaps
On the basis of record. Otherwise, no. Otherwise, the prayer, at least this part, prayer. Regarding contemplated and proposed eviction from this 8 bigha so and so, dark number 13, pattern number so and so. They have primacy established the case. Subject to, and if you can prove that this is railway land by way of records, then provisions of Public Premises Act will come into picture. So, what time? Next Thursday
No, my lord.
or Tuesday?
Please, my lord, minimum 2 weeks, my lord. These are two, these are all.
Make an attempt, otherwise I'll
Documents,
forget.
My lord,
Make an attempt, otherwise I'll forget again.
at least 2 weeks. At least 2 weeks.
Mr. Goswami,
Because
you are the
serve to-
custodian.
Custodian of those documents. my
You
lord.
are the custodian
Because
of the
from one
record.
document, so
And,
they have paid some
disbursement.
part of the money.
They have to merely pay the money.
That has to be there.
Award has to be there of that particular case. If no award within 1961, goes.
But at least in my affidavit, my lord, we have shown that part payment has been made. The other payment also. I'll try
That
to
will not
locate, my lord.
substantiate your case.
But whether they have
Pick and choose
disbursed
will
or
not do. Award in black and white and disbursement of money in black and white. Some, because they have purchased the land by registered post. Oh, sorry, registered sale deed.
And also will have taken permission for construction. Everything is.
Yes, everything is going on. And you are sitting over the matter. It appears. You have estate officials, large
My
establishment.
lord, that happens in every case. my lord.
No, still you have an
Feed
estate
is on,
officer.
feed there, my lord, everywhere.
No, Mr. Bogroghi, Railway has the largest establishment regarding estate.
Yes.
That I know.
They have the largest
In fact, my
establishment
lord, it may not be only in India, my lord, all over the world.
all over the world.
The largest number of
Yes,
employees.
so
also.
many estate officers looking to protect the railway land. Maybe they know this is not our land at that point of time.
They know, my lord, that it is railway land.
No.
They choose to close their eyes, my lord, sometimes.
I heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. P. Bharadwaj, learned counsel for the petitioners. Mr. A. Borgodogi, learned standing counsel,
Well,
railways, for the respondent
One and
number
two,
1
my
and 2. And Mr. N. Goswami, learned counsel for the respondent number
4, 5, and 6.
4, 5, and 6.
you know,
Revenue, as you are standing as revenue. Okay. None has appeared for the respondent number 3. Today on call, poster. Where the issue involves an area of 8 bigha,
1 katha, 14 lectures.
1 katha,
14 lectures.
4,
14.
1, 14 lessons, covered by Dag number 13 and Pata number 101, situated village, that's not Jalukbari, Moja Jalukbari, district Kamrup Metro. Full stop. The standing council, railways and the learned junior government advocate, Assam, shall produce records on the following two issues. 1, whether after declaration under section 6 of the Land Acquisition Act 1894 within brackets since repealed on 25/5/1959 in LA case number RLY full stop ACQ full stop Roman 12 stroke 21 stroke 59 comma any award was passed under section 11 of the said act, and if yes, comma a copy the details of the said award. Secondly, 2 and if any award is passed, the whether any compensation amount was disbursed to the landowners, the then landowners of that particular landowner within bracket S. You purchase the land from different landowners, not
Different
single,
land-
not single.
No, different.
Landowners of the subject land. I got subject land, subject land. Lays the case on next Thursday.
Well, at least 2 weeks, my lord.
Hmm? From Guwahati?
My lord, search for these documents of 1959,
No,
my lord.
first the information. If no award, goes everything. Both.
7-11.
7-11, or you can take 12-11
12-11.
at the
That
best.
would be better.
This is the case as part of.
Highly approve.
And Mr. Borgotogi and Mr. Goswami, writ petition is to be decided on the basis of pleadings. There is no mention about award in these pleadings.
Items 2 to 4.
Yes, your lordship. Two is the methods where my lord allotment is given, but during COVID, they are dispossessed. So only simple prayer is that let them restore the possession because it is the GMC market, my lord.
Yes, Mr. Bora?
Their claim is they have been allotted temporarily. During COVID, when it was empty, someone others have occupied it. In the meantime, eviction has been carried out.
Hmm?
In the meantime, eviction has been carried out.
We don't know about the matter. He simply said that is why I asked you.
May I please, your lordship?
Yes.
As for the respondent number 5, lordship,
Hmm.
and in item number 2, lordship.
Yes.
My senior BD Goswami was here, lordship, but personal accident, he went to the Jalukbari, lordship. So I feel.
Oh, I have seen him. I have seen him. Oh, yes, he was there. Then Mr. Boru was somebody else then.
My lord, then
He is connected, I think.
connected, my lord, what happened, my lord, as my learned friend said, that LOT, we are the LOT, and they implemented that they also claim that that portion.
Well, I also take the instruction because petition was done much earlier.
Yes,
After the lead petition was done. I'll also give the up-to-date
Yes, sir.
instruction of it at present situation. my lord.
Okay.
so after eviction, we should have put in possession, that was not done, that is my simple prayer.
Okay.
So my lord, we didn't charge we are waiting for a long time, my lord, we are LOT. And cannot do business, my lord, and going to then. Very short.
Okay, when it be sudden emergency on the part of Mr. Goswami, we have to accommodate. He was sitting there
Yes, yes,
since morning.
Thursday.
Not Thursday, this
Saturday.
Thursday. We can
Holiday, my lord.
we have to postpone
Next
it.
week, my lord.
All next week filled up. Okay, we can put on 12 like the other one. Okay, heard Mr. M.J. Burwal and Council Board of Petitioners. Mr. S. Bora, standing on GMC. And Mr. J. Gogoi.
JM Gogoi, lordship. Respondent
J.
number 5.
N or M?
JM.
M. Gogoi. Learned Council Board responding of 5. Are present. Post of Mr. Gogoi. Learned Council representing has submitted the leading council. Mr. BD Goswami. For the respondent of 5. Due to sudden emergency, has to leave the court premises. He has thus prayed for listing of the cases on another date. Post of Mr. Bora, standing as a GMC, has also submitted that he will make endeavor to obtain instructions, up-to-date instructions within a week, post of as sought for, and list the cases on 12.
Just 5 to 11.
Raw petroleum coke,
lord, my lord.
calcined petroleum coke.
My lord.
Okay.
In fact, your lordship directed me to file a compilation. Yeah.
Okay, then before starting, then we can take a short break to 5 minutes.
In fact, my side, I have already
completed.
So far, no, I have so far this thing. The journey of coke and coke in all its forms, including raw petroleum coke and calcined petroleum coke.
I'll just refresh your lordship.
That right from the judgment,
India Carbon starting from,
then up to latest.
My lord.
That I have noted down.
Exactly, my lord, that is.
I have noted down.
My lord.
Now the facts of this case
But that's why you're.
and the relevant provisions of Assam value-added tax that I have to
I will just,
understand.
thereafter,
No, so far the controversy regarding coke, then central sales tax, section 14, 15,
exactly.
and both are same. Interstate trade and commerce,
In fact, after,
there shall not be double.
in fact, after 5 months or 4 months also, your lordship remembers everything.
No, I had a note so I could understand. But
I
so
do-
far, Assam value-added tax
My lord,
and the factual aspects of
Right,
this case.
I'll just take your lordship to the
Okay.
relevant and.
Okay,
thereafter-
we'll just resume.
My
Yes,
lord.
Mr. Buru.
Mr. B. Gogoi is appearing for this matter.
But in the compilation, you have also.
Yes.
Phase 1. I've given Article 286 of the Constitution of India.
Article 286.
My lord. Phase 1, my lord.
Yes.
In excise, my lord, because of Article 286 of the Constitution of India, the Central Sales Tax Act 1956 was enacted, my lord. Because you two, your lordship, you see, Parliament may by law formulate principles for determining when a supply of goods or services both mentioned in so and so or so and so.
Formulate the principles for determining when a supply of goods or both individual mentioned in clause. Principles.
My lord. And the first, your lordship, you see, no law of a state shall impose or authorize the imposition of a tax on the supply of goods or services or both where such supply takes place outside the state or in course of import of the goods into or export of the goods outside the territory of India.
Hmm.
Thereafter, I may take your lordship directly to first page 7, my lord, section 14 of the Central Sales Tax Act. One, my lord, certain goods to be of special importance in the interstate trade and commerce. It is hereby declared that the following goods are of special importance in interstate trade and commerce, and lordship may see IA,
Coal.
coal, including coke in all its forms, but
Hmm.
excluding charcoal.
Hmm.
Next, I've given, my lord, section 15. At your lordship find at page 14.
14. Okay, 14. 10,
And you also see 15B, my lord,
15 page.
page 14, my lord,
15
B,
B.
where a tax has been levied under the law, under that law in respect of the sale or purchase inside the state of undeclared goods, and such goods are sold in course of interstate trade and commerce, and tax has been paid under this act in respect of the sale and purchase in course of interstate trade and commerce, the tax levied under such law shall be reimbursed to the person making such sale in course of interstate trade and commerce in such manner and subject to such condition as may be
Okay, such law means Assam value-added tax.
local law.
Local.
My lord,
So Assam value-added tax act.
my lord.
Okay, shall be reimbursed to the person making such sale in the intercourse trade or commerce in such manner
My lord,
and subject to such conditions
as may prescribe.
as may be provided in any law in force in that state.
So
Okay,
if any person, my lord, purchases the coke, declared goods inside the state,
pays tax.
pays tax, and makes the sale goods, the sale of that goods inside, outside the state
imposition of interest rate in commerce and makes payment of the CST, then the tax paid under the local law shall be reimbursed.
So local law is Assam Value-Added
Assam.
Tax. In such manner and subject to such conditions.
Conditions.
So manner and conditions
My lord.
will be in Assam Value-Added Tax.
Now, section 50 at page 3, my lord.
Section 50. PS3, yes.
This is the provision for refund, my lord.
Yes.
Subject to other provisions of the act and the rules made thereunder, if it is found that the assessment, reassessment, as the case may be, that a dealer has paid tax, interest, or penalty in excess of what is due from him, the prescribed authority shall, on the claim being made by the dealer in the prescribed manner and within the prescribed time, refund to such dealer the amount of tax, penalty, and interest paid in excess by him.
So this in excess of what is due from him
My lord.
means that the tax paid under Assam Value-Added Tax.
My lord.
Okay. The prescribed authority on the, so a claim has to be made
My lord.
by the dealer in the prescribed manner
Prescribed time.
and within the prescribed time.
My lord.
These are the condition precedent,
And
prescribed manner and prescribed
my
time.
lord. Now, page 16, you also may see.
Page 16.
My lord. The claim applications were filed on different dates and they are annexed to the writ petitions copy. Page number of the writ petition has been given.
Okay. And what is the prescribed time?
Now, prescribed time is, my lord, from the date of the assessment. That is in the rules, the color bed rules.
This book,
My lord.
this book.
Wet.
Wet.
That will do. That is rule 29, my lord.
Rule 29.
My lord.
1 minute. Rule 29. Tax rules.
My lord. Wet rules.
VAT rules. Rule 29.
My lord. 180 days from the date of the assessment.
A refund. An application for refund under subsection 50 shall be made in Form 37.
My lord.
Okay, that prescribed manner is Form 37.
My lord.
From the date of assessment or reassessment. Here is a question of assessment or reassessment.
My lord, after the assessment, in the assessment, no order was passed for refund because the matter was pending in the High Court. After the decision of the Supreme Court, they passed a fresh order.
Okay. For the timing, okay, rule 29 1A.
But there is no dispute, my lord, in the order also, they have not said that you have delayed in submission of the claim.
Okay. Even made after the statement may be repeated, sufficient cause for. There is a proviso also.
My lord, for condemnation.
Okay. This is the only relevant rule.
My lord.
Okay.
Now, page 17, my lord,
Page 7 of the paper book.
paper book, my lord.
Yes.
The refund applications were, my lord, proposal for approval of the sanctioning of the refund by the Commission of Taxes. The Commission of Taxes approved it and forwarded it to the government for sanction.
These are years.
These are different years, my lord. And the page number of the order I've given, my lord, in the petition.
Page 18,
My lord, at 17, my lord.
page 17.
My lord.
Okay, assessment year. What is this date of communication?
Date of communication, my lord, that by which the commissioner communicated, my lord.
Okay.
Communications of the commissioner.
Hmm.
And the amount and the page number of the order communication.
This is by,
Commission of Taxes.
let us have,
Well, you'll
I
also
look-
see at page 198.
okay, Commissioner of Tax.
Well,
He is the prescribed authority.
Lord, he's the highest authority, my lord. That
Okay.
after the assessing authority, it goes to the commissioner, my lord.
Okay. So this section, you said 50. The prescribed authority is Commissioner of Tax.
My lord, first of all, prescribed authority, the assessing authority. After that, my lord, the matter is referred to the higher authorities. And since the amount is more than the prescribed limit, it has to go to the government for sanction.
198.
From the Supreme Taxes, it go to the Deputy Commissioner of Taxes. And Deputy Commissioner of Taxes forwards it to the Commissioner of Taxes. And thereafter, ultimate approval is given by the Commissioner of Taxes and it sends to the government.
One 198.
My lord.
Yes.
All other are similar, my lord. I may read one that will be.
Oh,
clear.
yes.
With reference to the above, I have the honor to submit herewith the proposal seeking approval of the sanctioning of the refund of so-and-so only to so-and-so for the assessment year so-and-so under the Assam Value Added Tax Act 2003. The refund application is processed in this commissionerate with the views taken from the legal members of Assam, while letter number so-and-so dated so-and-so, and the direction of the government while letter number so-and-so dated so-and-so, where it has been directed to process the refund proposals of so-and-so, Tinsukia similarly as so-and-so and Guwahati Carbon Limited. While processing the refund proposal in this appeals court, it has been noted that the dealer has submitted the entire refund proposal before the concerned Assistant Commissioner of Taxes in time to time, but due to pendency of the legal pronouncement from the Honorable Supreme Court of India in the similar occasion in the matter of Government of Assam versus Guwahati Carbon Limited so-and-so, subsequently numbered as so-and-so, in respect of the genuineness of the refund requirement section 15B of the 19th, all the proposals of refund of the dealer were kept pending before the concerned Assistant Commissioner of Taxes. In view of the judgment of the Honorable Supreme Court in the matter of so-and-so, subsequently numbered as so-and-so, the common identical question of law has been settled, and on the strength of the judgment and order dated so-and-so, the refund application has already been sanctioned to the dealer who involved in the legal issue. It is pertinent to mention herein, the dealer Digboy Carbon Limited was not involved in the legal issue as mentioned above before any competent court. As per the judgment and order of the Honorable Supreme Court and as per the views of the LR Assam, there is no dispute with regard to the tax amount refundable, reimbursable to the so-and-so under section 15B, but a question arises regarding applicability of the interest to the dealer on the reimbursement of the amount of tax. So Lordship may kindly note, my lord, the Commission of Taxes has held, my lord, there is no dispute about the amount of refund. To clarify the issue in respect of the applicability of the interest on refunded amount, this commissioner has taken a view from the LR Assam, wherein the LR Assam has opined that the dealer shall be entitled to 9% interest per annum for the period commencing from 90 days of the application, claiming refund till the date when the refund is granted. But in the similar occasion, refund proposals of so-and-so, the LR Assam has suggested that if the department allowed with 10% interest from 12/7/2013 for the period not included in the court case, then the amount will be obviously less than the amount if calculated with 9% interest from the expiry of 3 months, raising the claim of the dealer. As directed by the LR Assam, the government of Assam had allowed 10% interest from 12/7/2013 to Brahmaputra Carbon Limited, Guwahati Carbon Limited for the periods from so-and-so with the undertaking from the dealers mentioning no further claim of interest and the post periods with 9% simple interest in the section 52 of the so and so act.
There was some kind of 50%.
My lord, what happened earlier, the Supreme Court, my lord, when the directive for 50%, then the Supreme Court said the 9% interest from the date of the judgment. So now they felt that, my lord, is the 9% interest as per the act is to be paid, for that has to be paid from the 3 months from the date of the filing of the claim. So they took undertaking that 10% from the date of the judgment, or whatever is there, if you agree to it, then we can it. And the SSC also gave undertaking that we will take this amount.
But this part will have consequence in these mature petitions.
No, interest part, because this has already been admitted that
Oh.
they gave the, I'm sorry, you lost it. They gave that, you gave an undertaking that you will take only 10% interest from this one and not claim as per section 52 of the act. And the dealer has given undertaking that this 10% interest will be sufficient, my lord.
Okay.
Now, the same principle is taken in this matter as asked by the comment, why number so and so dated so and so. In this context, it will be appropriate to give a brief outline of the facts bearing the refund application or being interest thereon. So and so, which is a private limited company, is engaged in the manufacture of calcined petroleum coke from raw petroleum coke. The dealer makes local purchase of raw petroleum coke from refineries in Assam and sells the finished product calcined petroleum coke in course of interstate and commerce. The dealer filed refund annual return in so and so, audit report claiming reimbursement on section 15B of a sum of rupees so and so for the assessment year so and so on account of VAT paid on purchase of raw petroleum coke, which is a declared goods on the ground the CST was paid on the interstate trade and commerce, which is the same item, and citing the judgment of the Guwahati High Court in India Carbon so and so. It is pertinent to mention herein that section 15B of the act provides for reimbursement of local tax paid on interstate sales or declared goods subject to the condition that the CST is paid on interstate trade goods, declared goods. Conditions of the CST assessment, completion of the CST assessment. The audit assessment of the dealer for the period so and so was done by the Deputy Commissioner of Taxes Zone on 12/3/2012.
Otherwise, it was kept pending.
Well, assessment was done, but the refund was not considered.
Oh.
In
Okay.
2012, because the matter was pending before the Supreme Court.
Hmm.
As per the assessment order, the amount reimbursable under 15B of the Central Sector for the year so and so stands at, and the assessing authority has allowed interest at 10% amount rupees so and so from 2013 to 17, and so the total amount refundable as per the assessment year comes to so and so.
What is this 12/7/2013?
My lord, I've given yet in the compilation, my lord. In fact, the 12/7/2013 order is in the petition itself,
12/7/2013.
my lord.
What is the significance of this
My
particular
lord,
date?
after the judgment of the apex court,
Which judgment? Just
that Guwahati Carbon, my lord, by which
is it part of the this compilation?
comparison that order is there, my lord. You'll also may see one order, my lord, that will be, I think,
I think page 73.
my lord, I'm just giving you also. You'll also may see page 154,
154.
my lord.
154 of the repetition.
Petition, my lord.
One 154 is or page 74 of the compilation.
By 74 is compilation, you'll also may see
74,
is the first order.
73. In bold, you have said 12/7/2013.
Well, this is the, my lord, the order which was passed and on an appeal filed against the judgment of this honorable court. By this honorable
So
court.
this is the date,
My lord,
73 of your compilation.
my lord.
Bold year 12/7/2013.
This is Guwahati Carbon Limited 12/7/2013. So they calculated the interest from
And
the 12.
This is the significance.
My lord.
Okay. Page, we are reading at page 190,
I was reading from below page 198
198,
and at page 199 below.
199. Okay.
They are filing of the returns and claiming of reimbursement.
Completion of CST assessment.
My lord.
Ah.
The audit assessment of the dealer for the period so and so was done by the Deputy Commissioner of Taxes, Tinsukia Zone on dated so and so.
Hmm.
As per the assessment order, the amount reimbursable under section 15B of the Act of 1956 for the SS 67 stands at, and the assessing authority has allowed interest on so and so from so and so to so and total amount refundable as per the assessment order so and so. Forwarding of the refund proposal by ACT. The ACT being satisfied with the proposal forwarded the amount the same to the DCT Tinsukia, and the DCT Tinsukia being satisfied with the refund proposal forwarded the same to the concerned ACT has provided the same to the Apex office. Obtaining the opinion of the legal membership and interest claimed. On the claim applicability of the interest on the VAT payment reimbursement section 15B of the Brahmaputra, the views of the LR was sought for through government wide office letter number so and so. The learned LR has furnished views on so and so, which has been communicated by the government on so and so. So the government will procure the opinion from the LR and the LR gave the opinion. It is noted that section 52 of the Assam Value Tax, any registered dealers, one dealer entitled refund in pursuance in the order of assessment under this act shall be entitled to 9% interest per annum for the period commencing up to 90 days of the application, claiming refund till the date on which the refund is granted. Thus, this is a statutory interest. It is observed the refund payable under section 15B of the Act entails claim of statutory interest under section 52 of the Act. Generally, rate of interest and the date of entitlement in respect of the similar claims shall be in accordance with the provisions of Assam Value Tax. Therefore, it maybe not be correct to held that the interest order of the Honorable Supreme Court dated so and so will regulate the rate of interest or the date of entitlement interest in all the cases. So they themselves admit, my lord, that that interest which was Supreme Court granted will not be applicable in all cases. Now, present orders of the Honorable Court is applicable in respect of claim for 2004-5 only. Therefore, rate of interest and the date entitlement in respect of the subsequent assessment year are to be determined in accordance with section 52 of the Act and not by the interim order. However, finding of the Honorable Court insofar as it relates to the claim for refund of so and so being declared goods is equally applicable in the present all similar claims. As returns for the assessment year so and so have already been allowed with 10% interest with effect from 12/7/2013, amount refundable are obviously less than the amount actual amounts if calculated with 9% interest from the expiry of 3 months, raising the claim of the respective years as per section 52. This may, however, be recalculated by the department, and if found to be so it may be better not to reopen the same in the absence of the claim of the company. For the present so and so assessment year with 10% interest, the department may due to the regions allow the sanction of the proposed refund to consent of the undertaking from the so and so with no further claims. So they wanted that the undertaking should be taken from the SSC, that they will give 10% interest from the date of the judgment and no further.
Date of that judgment
Of
or
the Supreme Court.
12/7.
My lord. In the meantime, the government of Assam, by letter number so and so, rejected the similar refund proposal of Guwahati Carbon Limited for the years 2004-5 under GST Act. On the basis of such communication of the government, the Commission of Taxes, by letter number so and so, dated so and so, directed the refund proposal of the rejected the Brahma Project section 15B of the Act of Brahmaputra Carbon Limited for the assessment year so and so. Being agreed, the Brahmaputra Carbon Limited approached the Honorable Guwahati High Court by way of writ petition number so and so. For earlier assessment year, my lord, one of the SSC, the refund applications were rejected, and then they filed a writ petition, which ultimately went to the Supreme Court. The Honorable Guwahati High Court allowed the petition, holding that the Honorable Supreme Court in the case of State of Bihar and so and so had already held the RPC and CPC are same product, and the controversy need not be entered again. Filing of the SLP by the case state and dismissal of the appeal. Being agreed, the state government filed SLP before the Supreme Court, number so and so, and subsequent number so and so. The Honorable Supreme Court in so and so passed following orders, interim order. 50% that the interim order is there, I can skip over. That last. Finally, the Supreme Court in the number so and so dismissed the appeal filed by the government of Assam, resultingly the amount of tax payable under the RPC stands reimbursable to the dealer. Following the interim order passed by the Honorable Supreme Court, the Honorable Guwahati High Court allowed the payment of the simple interest at the rate of 10% per annum to India Carbon Limited for the assessment year so-and-so to so-and-so. In a similar case, my lord, the India Carbon Limited also this Honorable Court, following the decision of the Supreme Court, directed the refund along with 10% interest from the date of the judgment. Now, this is important. No? Assessment pursuant to the Honorable Supreme Court's order. In the wake of the Honorable Supreme Court's order, the assessment was completed by Jurisdictional Assistant Commissioner of Taxes Tinsukia on 12/6/2018, allowing the claim of the dealer of reimbursement of the local tax paid of purchase of Toronto in the claim so and so. So after the judgment of this, the apex court, the assessing authority passed the order determining the amount of refund payable to the petitioner.
Okay, assessing authority is Assistant Commissioner of Tax.
My lord.
Okay.
All those orders are annexed in the petition. Your lord.
No, that is, this 7. Come to the previous page,
My lord,
200,
200. Lord.
para 8.
My lord.
That is the thing. The ACT Tinsukia unit being satisfied, the refund proposal order forwarded the same to the DCT. It is to be read with this
Well, this was the earlier one,
or
But-
earlier one.
but after the Supreme Court judgment, he passed fresh order.
Okay, fresh order. This is assessment or reassessment?
Lord, he has mentioned that invoking the power in the section 42, that is the to give effect to the order of the Supreme Court.
Okay,
But in any case, my lord, when the Supreme Court judgment is there, then the either order has to be rectified or the order has to be passed.
okay. 12/8/6/2018,
My lord,
allowing the claim.
my lord. So next, my lord, however, in the event it is found the payment of interest at the rate of 9% per so and so will be less than the amount actually paid or proposed to pay, suitable adjustment correction may be made in the light of discussions above, barring the assessment year 2004-5. Hence, simple interest at the rate 10% may be allowed to the dealer from so and so as per the interim order of court so and so, and further claim of 10% simple interest by the period from so and so till the final order assessment order. As per section 50 of the Rate of So and so Act, with the provision section 174 GST provide for refund of an amount paid in excess. As the amount to be refunded exceeds rupees 50 lakhs, prior approval of the government is necessary as per section 29 so and so of the rules. According to the proposal forwarded so and so.
29(1)(e).
My lord, if the amount is more than 25 lakhs, my lord,
Rupees is when the amount to be refunded is more than rupees 3 lakh, prescribed shall be prior approval of the Deputy Commissioner, because the Deputy Commissioner shall not approve the refund if the amount refunded exists 10 lakh, but for
rule, my lord.
when the amount to be refunded is more than 50 lakh, a commissioner shall take prior approval. Okay.
At that time it was 25 lakhs, my lord.
In this book, it is
50 lakhs, 50 lakhs, my lord. I'm sorry.
It is rule 29.
Rule
29(1)(e).
Yes.
Rule 29(1)(e)
my lord.
correctly reflected here in this order, page 202,
My
third
lord.
paragraph,
Same, my lord.
as per provision of rule 29(1)(e).
It says section.
Huh?
Should be rule.
Oh, that he mentioned wrong.
No, it is
section.
okay. Rule. Okay. Okay. Misquoting of provision, okay.
Cut paste, my lord. So, my lord, after that, my lord, is signed the submitted-
Accordingly, the proposal
was submitted.
is forwarded to the government for according its approval. The fund of so-and-so industrial estate for assessment year on account of tax paid on purchase of RPC in terms of so-and-so in compliance with NRDP duly signed by the undersigned, the amount proposed is debitable. Yes, this is one. We are concerned with how, what, this is 2006-7.
Or subsequent, my lord, are annexed in the petition, my lord. Like page 203. will also find
You have given this,
chart, my lord, I've given.
1 minute. 200.
7-8, you'll also find page 203.
Okay, 20, similarly worded.
Similarly, exactly similarly.
Amount is different and year is
That's
different.
why amount also I mentioned, my lord,
In this page 17 table,
my lord.
so
Sec-
amount is different,
Date is-
and date is different
That is some cases.
and year is different.
Year is different. And all are annexed, my lord.
And all are on 25/10,
In some
2019.
cases, my lord, 23/12/2019 also.
Okay, okay.
So this was the situation where the refunds were there.
Hmm.
Now, after this part pending, my lord,
This was forwarded for approval under section 29(1)(e) after reaching satisfaction by the Commissioner of Taxes
my lord,
regarding validity of the refund proposal.
my lord.
Okay.
Now, after that, my lord,
Hmm.
the new Commissioner of Taxes who was there,
Two, yes,
which will also find page 238.
238. Hmm.
He has rejected the refund claims again.
Hmm.
Although there is no power
Hmm.
under the Act for review of the order passed by the Commission of Taxes earlier,
For all the years,
all the years. my lord.
2000. Okay, let us read that,
Yeah.
then we can understand.
Second line, you will also see first order 2006-7 to 2013-14.
Yes. Okay.
I will also see the regions which has been given. You will also see, my lord.
Yes.
Finality of the audit assessment made by the General Commission of Taxes for the assessment year so and so, so and so. The dealer had claimed the reimbursement of the tax paid on the purchase of raw materials, raw petroleum coke in terms of the provisions of section 15B of the Central Sales Tax Act and 15B of the so and so Act. The matter was referred to the General Deputy Commissioner of Taxes and Tinsukia for completion of the audit assessment, specifically mentioning that the refund claims claimed by the VAT on so and so in the order so and so. The General Deputy Commissioner of Taxes passed the orders on the so and so Central Sales Tax Act for the assessment of so and so on 10/3/2012. However, the assessment order did not allow the claim of the reimbursement of the tax paid on purchase of raw materials, in spite of the fact that the cases were referred to the General Commission of Taxes for audit assessment so and so. Now, your lordship has noted in the earlier order, it has been mentioned that the refunds claims were not processed by the assessing authority on the ground that the matter was pending before the apex court. Now, the Commission of Taxes is saying that the earlier assessment order which were passed, there the refund claims were not considered in 2012. Now, what he is saying, look, the dealer did not challenge the assessment order made by the concerned Deputy Commissioner of Taxes Tinsukia and did not file any statutory appeal revision for not allowing the disbursement of tax paid on purchase of so and so. Now, my lord, the question of filing appeal will arise only when the refund claims are rejected. There was no rejection order of the refund claims. So the question of filing the appeal against that order does not arise.
Why is saying, however, assessment order did not allow the claim of the reimbursement of tax?
My lord, he's saying that, my lord, in the order of assessment, the refund claim was not given. And the earlier commissioner said, my lord, that refund claims were not considered because the matters were pending before the apex court.
Yes.
So he has given a reasoning that why the refund claims were not considered. In 2013 only, the apex court judgment came.
Just a query.
My lord,
29, rule 29.
my lord,
E.
my lord. 29(1)(e).
That during early hearing, that was a question
My lord,
arose in my mind.
my lord,
This commissioner is speaking about deputy commissioner.
my lord,
Rule 29.
my lord. Indian Union. My lord,
Read 29E,
E.
1E.
my lord. My lord,
If it involves more than 10 lakh,
my lord,
it does not have to exercise any power.
no,
Deputy Commissioner shall not approve the refund if the amount to be refunded exceeds 10 lakh but forward such cases to the Commissioner for approval. It does not have any power. So did not allow or allow has no value.
my lord, the up to 10 lakhs, my lord.
He has the power to approve. That meaning thereby, say, just power to appoint includes the power to cancel. Power to make an appointment by an appointing authority includes, by the General Clauses Act, power to cancel the appointment.
Right.
So power to approve has the power to disapprove.
My lord,
Here is a case of Deputy Commissioner who has the power only to approve up to 10 lakh.
my lord,
So he has also not the power. So meaning thereby, he has no power to approve beyond 10 lakh. Meaning thereby, he also does not have the power to disprove any claim beyond 10 lakh. Can it be understood like this?
my lord, it has to be.
Just
my lord,
posing a query. Posing a query.
The commissioner will also have no power to reject. Lordship will see the next line of that paragraph.
No, I'm just,
Just posing the query, you answer.
let me say, my lord, may I read once, my lord?
Yes. The Zonal Deputy Commissioner.
When the amount to be refunded is more than rupees 3 lakhs, the prescribed authority shall take approval of the deputy commissioner before sanctioning the refund. So if the amount is more than 3 lakhs, he will take the approval of the deputy commissioner before sanctioning the refund. Up to
So,
3
prescribed authority is Assistant Commissioner of Tax.
my lord. So up to 3 lakhs, he can himself sanction it.
Yes.
After 3 lakhs, my lord, he has to take the prior approval of the deputy commissioner. Now we are asking for the C. The deputy commissioner shall not approve the refund if the amount to be refunded exceeds rupees 10 lakhs, but forward such cases to the Commission of Taxes for approval. If it is more than, my lord, less than 10 lakhs,
He can
Then-
approve.
Commission of Taxes approval will be necessary. Here the question of rejection is not there. Assuming, my lord, I find that the amount is refundable up to 2,50,000. I don't need any approval of anybody. I can sanction it. Assessing authority.
Assistant Commissioner.
If it is more than 3 lakhs, but less than 10 lakhs, then he has to take the approval of the Deputy Commissioner of Taxes. Now, if it is more than 10 lakhs, then you also may see if the amount to be exceeded rupees 10 lakhs, forward the such proposed Commissioner of Taxes for approval. If more than 10 lakhs is there, he has to forward it to the Commissioner of Taxes for approval. Now, further similar, where the amount to be refunded is more than 50 lakhs, the Commissioner shall take prior approval of the government before sanctioning such refund.
Hmm.
So this is only for sanction of the refund. The question of rejection is not there.
Yes, that is what I am asking.
My lord, the question is that if it is more than 50 lakhs,
There is a question of 50 lakh.
my lord,
So obviously beyond 10 lakh.
so he has to send it
So
to the-
he has no power to
sanction it.
sanction it. And to make a comment on disapproval also.
My lord, if it is disapproved, there is no question of sending it for sanction.
Yes.
Assuming, my lord, the claim is not entitled, he is not entitled to it. Then the question of sending for approval does not arise. It will be sent for approval only when somebody is entitled to the refund.
Hmm.
But the amount is more than 50 lakhs, then he will send to the government.
No, I am just asking.
My
First authority to decide on the refund proposal is
Assistant-
Assistant Commissioner of Tax. And he decides about the amount of proposed refund.
my lord,
Now, if it is below 3 lakh,
he can give it.
he on his own without sending it to anybody, can approve.
My lord,
Now, if he finds that it is beyond 3 lakhs, it may be up to crores also.
my lord.
So he sends it to the commissioner or deputy commissioner. And
Absolutely.
if the deputy commissioner finds
More than 10 lakhs.
10 lakh, so without doing anything of his own input, whether that is to be read,
So the deputy commissioner will verify it.
verified.
Verify, after verification, if you find that yes, it is refundable, then he will send it to the commissioner for approval,
Okay.
prior sanction. And if it is more than 50 lakhs, if the commissioner finds that, this amount is refundable, then he will have to send to the government for prior sanction because the amount is of more than 50 lakhs.
So in the earlier round, the Commissioner of Taxes, since it found that more
Yes,
than 50 lakhs, he forwarded it to the government for sanctioning, before
But-
sanctioning
But
such
Commissioner of
reports.
Taxes was satisfied that the amount is refundable. Otherwise, the question of forwarding to the government does not arise. The question to forward for approval of the sanction of the government will arise only when the Commissioner of Taxes is satisfied that yes, this amount is refundable. Assuming, my lord, as Commissioner of Taxes, I am not satisfied that this amount is refundable. How I can send it to the government for the sanction? Sanctioning can be, my lord, done, sent for approval only when the Commissioner of Taxes is satisfied, yes, after verification. Otherwise, he could have forwarded in 2 lines. It received from Deputy Commissioner, forwarded to the Commissioner.
Okay. Mhm.
So he has to apply.
So there has to be application of mind.
Mind. And he must find that the amount is refundable. Then only he can send it for sanction.
Okay.
Otherwise, the question of sanction, seeking sanction does not arise.
Okay. Let us again come back to 238, para 2 onwards, so
Right.
that I can understand again. Finality of edit assessment.
Now, I was reading, my lord.
Now,
But
para 2, just again, one for
Two,
at
Lord.
my request is.
the dealer had claimed reimbursement of tax paid on purchase of raw materials, raw petroleum coke in terms of provision section 15B, railway section so and so value tax. The matter was referred to the General Deputy Commissioner of Taxes in Sukia for completion of the audit assessment, especially mentioning about the refund reimbursement claim for VAT paid on the purchase of.
So there is no dispute about this.
No. The General Deputy Commissioner of Taxes framed the assessment order, central sales tax rate for the period so and so. However, the assessment order did not allow the claim of the reimbursement of the tax paid on purchase of raw materials, in spite of the fact that the claims case were referred by the General DCT for audit assessment, especially mentioning so and so. So the commissioner is saying that he has not passed any order on the refund claims. In the earlier order which I have annexed, there is no order that the claims are rejected. There is no order. He had not considered the refund claim, and which the Commissioner of Taxes, earlier Commissioner of Taxes, had mentioned specifically that the claims were not kept pending because the matter was pending in the Supreme Court. Am I clear, my lord?
In the earlier round, if I come back to 199.
Mine. 199, my lord.
Para 3. Completion of CST assessment.
My lord.
The audit assessment of a dealer for the period 2006-7 was done by the Deputy Commissioner of Taxes, Tinsukia Zone,
My lord.
on dated 12/3/2012, the
Right.
same date.
My lord.
Here it is 10/3
My lord.
in page 238. Now next page.
My lord.
As per the assessment order, the amount reimbursable is so and so, and assessing authority allowed 10% interest. Okay, done.
My lord.
Para 8.
My lord.
The ACT Tinsukia unit being satisfied with the refund proposal forwarded the same to the DCT Tinsukia zone.
My lord.
The DCT Tinsukia zone being satisfied with the refund proposal.
That's why I submitted, my lord. That after-
Forwarded by the concerned ACT has forwarded the same to the Apex office. Now, this is contrary. He satisfied
My lord.
earlier, DCT. Is it not?
My lord, the assessing-
Recorded,
My lord, the assessing authority.
recorded, Yes.
assessing authority was satisfied, thereafter he forwarded
DCT satisfied,
DCT was satisfied, then he forwarded to the apex office.
means by
Taxes.
Commissioner of Taxes.
Commission of Taxes was certified, then he forwarded to the government.
Okay. Hmm. Okay.
Now, Your Lordship, see, the dealer did not challenge the assessment order dated so and so by concern the Commission of Taxes Tinsukia, Deputy Commission of Taxes, and did not file any statutory appeal for not allowing the reimbursement of taxes paid on the purchase of RCP. It means the dealer has accepted the assessment order. Therefore, the assessment order Jonoso has attained finality, and after the expiry of the period of appeal revision provided in fact, the pendency of other proceedings cannot be a ground for not challenging the assessment order.
Hmm.
So, my lord, the Commission of Taxes is saying now that the earlier order, 2012, since it was not challenged, that attained the finality. The Lordship, further similar, it will be interesting. 3, my lord.
Hmm.
The Supreme Taxes for assessment year so and so, the dealer claimed reimbursement of tax paid on purchase of raw materials, raw petroleum coke in terms of the provisions of section 15B with the section so and so of the Act. The audit assessment for the year so and so were made by the Supreme Taxes under section 15B of so and so Act respectively. The assessment orders did not grant reimbursement of the tax paid on the purchase of raw materials so and so. The dealer did not challenge the assessment orders made in the Supreme Taxes and did not file any statutory appeal or revision for allowing reimbursement of the paid on so and so. It means that the dealer accepted the reimbursement, the order. Now, this is actually contrary to the earlier order of the Commission of Taxes, wherein it is said that since the matter was pending in the Supreme Court, the refund claims were kept pending. Now, subsequent Supreme Court decision below. In some cases, in similar factual situation, in the meantime, some other cases.
Which one you were reading? Page?
4, 239.
Four. Or not, okay. Okay, subsequent order, yes.
Now, he's saying that Supreme Court has so and so in the order by Guwahati High Court, and whether the amount are squarely covered by judgment of this honorable court in so and other so and been relied on by the High Court in the subsequent judgment appeal, it may be borne in mind that Digboi Carbon was not a party to the said case. So the Commission of Taxes is saying that the matter which was pending before the Supreme Court, the law which was laid down, in that the Digboi Carbon was not a party. Now, Lordship, Article 141, when the law is laid down by the apex court, that it's not so that it is applicable only in respect to the parties who are there in the Supreme Court. There are a number of judgments which were applicable to all. It is not so that everybody has to approach the Supreme Court for that, because there was no order in my case. In those cases, there was an order of rejection. So they came to the High Court. Other cases were kept pending. Now,
So far as there is no dispute regarding prescribed time and prescribed manner.
No. Reassessment by the Assistant Commissioner of Taxes. Based on the Supreme Court's order, an Assistant Commissioner of Taxes take up the case for reassessment. Section 42 of the Act passed the reassessment order allowing the refund application along with the interest thereon, the date on which so and so is there. The refund application forwarded to the Deputy Commissioner of Taxes, Tinsukia, John by God, Assistant Commissioner of Taxes, and the Deputy Commissioner of Taxes, on being satisfied with the refund, you also noted. Proposal forwarded the same to the Commissioner of Taxes, Assam. Relevant provisions of the AVT Act under which the reassessment was made. The Assistant Commissioner of Taxes Act invokes Section 42 of the Act for the purpose of the making assessment or relevant so and so. Below, however, is quoted below. 42 he has quoted. The Commissioner of Taxes is saying below that the Assistant Commissioner of Taxes could not have invoked Section 42 of the Act.
Oh, 42.
My lord.
Okay, where any court?
I've given in the note also, my lord. Type copy below. You'll also find page 2, my lord.
2. How this is applicable?
my lord.
How this is applicable?
Strictly, I am saying, my lord, strictly speaking, 42 is not applicable.
Hmm.
But the question is that, my lord,
Hmm.
that the Supreme Court decision was there and my refund applications were kept pending.
Hmm.
Earlier assessment orders, no order were passed.
Hmm.
Now, by putting the section, wrong section or something, my lord, the order was passed. Now, that order has attained finality. This order, which was passed in 2018, has attained finality.
Commissioner.
Will of the assessing authority,
Ah,
the assistant commissioner, we passed the order, has attained finality. As the Commissioner of Taxes is saying, the 2012 order attained finality. This order also attained finality.
the first and foremost point, I think, in view of the order passed by the Commissioner of Taxes
Earlier one, my lord.
earlier, we have to test this order if the earlier order is valid. And if it is not open for the commissioner to
My lord, that's why I
reopen
think,
the thing,
my
everything goes.
lord, the review power being not vested in any Commission of Taxes, one cannot review the order which was passed by the earlier Commission of Taxes and say that these are the grounds. No, it cannot be. He's not sitting in appeal.
He cannot sit in appeal over another order. So if review order is power is not available, review is a power to be given by the
My
statute.
lord.
Earlier, otherwise one cannot so moto assume that power.
My lord. Now, one more thing, my lord. Under the examination of the refund application, he cannot examine the validity of the orders of assessment. My lord, the order of assessment which is in passed in 2018, that power is not there while examining section 50 of the Act.
Hmm.
Section 50 of the Act is that whether it is refundable or not.
Hmm.
The Assistant Commissioner of Taxes passed the order and said that it is refundable.
Hmm.
The Deputy Commissioner of Taxes examined it and said it is refundable. The Commissioner of Taxes examined the odd cases and said that it is refundable and forwarded to sanction. Now the Commissioner of Taxes again.
At that time, only thing was only thing remaining was prior approval and sanctioning by the government.
That's all.
And if it is sanctioned, then commissioner, the next thing to be done by the commissioner is to release.
My lord.
So thing rested at that point for prior approval and sanction.
My lord.
So what was to be done remaining thing was by the government.
My lord. And the government, my lord, specifically said by taking the opinion of the LR that you take an undertaking from the dealer that he will accept 10%. That is from the government. And after that, an undertaking was taken from the dealer.
Yeah, well,
In fact, opinions were taken, my lord, from the learned AG. At that time, the senior standing counsel of the taxation department on the same case, and they both said that yes, they will have to be granted refund.
what does it mean by apex office?
My lord,
Apex office?
FX is the Commission of Taxes.
Because after para 9,
My lord.
because it appears that government was exercising its mind, applying its mind on the refund proposal.
My lord.
And LR's opinion taken.
Everything, my lord. And 10% interest. Why they
Yes.
will say that you take an undertaking from them, that 10% interest?
Yes. Yes.
In fact, I have a next that one also. Quote I say later too. I placed before Lordship the letter also.
Hmm.
Now your Lordship may see, my lord.
Where?
Next, the page 247.
240, yes. Hmm.
It is essential principle of law, those persons who do not challenge the wrongful action on the cases and accused with the same woke up after the long delay because of the reason the counterparts has approached the court, order and so, the backbenchers. In my case, the refund was not rejected. And he says,
Woke up after a long delay, only because the region had their counterparts who had approached.
he said, needless to say, Digboi party was not a party in the cases before the Supreme Court. Where is the question of Digboi Carbon being a party in the Supreme Court?
So he is dubbing you, he has dubbed you as a fence-sitter.
My lord.
Hmm.
Now, fence sitter can only be, my lord, if my claim was also rejected and I have not challenged it. My claim was not rejected. Whereas the person who approached the court, the claim was rejected.
Hmm.
Thereafter, you also see, from the above discussion, I do not have anything hesitation to held that the reassessment made in 2018 by the Jurisdiction Assistant Commissioner in size of powers so are outside the jurisdiction and void and deprived of any legal effect. Now, how, my lord, the Commission of Taxes, while considering the refund application, can say the order of assessment which was passed is devoid of any merit, my lord?
Hmm.
Further, as per the proposal of section 39 of the Act, the assessment after the expiry of the 2 years from the assessment year becomes time bar.
Hmm.
The original assessment being by the Deputy Commissioner of Taxes, the Superior Taxation did not allow the claim of the dealer for reimbursement of so and has attained penalty. So he said 12 has attained penalty.
Hmm.
But 18 will not attain penalty, though it was never challenged.
In 12, okay. Hmm. Hmm.
Mr. Dibokan was not a party again, repetition, my lord. So I reject the claim.
Okay, fence-sitter.
Mainly 3 grounds have been taken, my lord. Fence sitter, I have not challenged the earlier order of 2012. 2018 was null and void, the order was legal. And thereby, the refund applications are rejected. As you also correctly said, my lord, the most important issue is that whether the Commission of Taxes, new Commission of Taxes, sit over
Hmm.
the order passed by the earlier Commission of Taxes, whether any power is there under the Act.
Hmm. Review. Hmm.
There is no
Which
power
were challenged. Yes.
under the Act.
Okay. Hmm. Yes.
And thereby, in my humble submission, my lord, this order is absolutely illegal and without jurisdiction. Now, your lordship may kindly see, my lord, in the paper book, as page 42, I've given the judgment, first judgment of the Apex Court in 1971,
Same page
42.
42. Yes. Yes.
Now, thereafter, at page 46, my lord, a division bench judgment of this honorable court, the issue was that, my lord, after the judgment in 1971, the state made 2 entries, that one raw petroleum coke, another Kasai petroleum coke.
Read down.
That was laid down on the ground that no, you can't do it. Now, thereafter, you also see page 51, the Supreme Court decision,
Yes.
that raw petroleum coke and calcined petroleum coke are the same and they will be entitled to refund. Now, page 59, my lord, the introductory order 50% which was passed.
Hmm.
Then, my lord, Brahmaputra Carbon, page 61, the order of this honorable court, again, I'm sorry, page 59 is the dismissal of the SLP, my lord.
SLB.
SLP against the judgment in page 46. Following the judgment in
Mhm.
page 51. Then, my lord, again, the judgment of this honorable court, again, when the claim of some other SSC was rejected, page 61.
Hmm.
Then interim order was passed, page 71.
This is page 61 is what?
Follow the division bench judgment of this honorable court.
Hmm.
Again, my lord, when they said no, it is, my lord, earlier judgment is there, so it is covered. Then the interim order was passed by the apex court 50% at page 71.
Page
Page 71 is the
71.
dismissal of the SLP.
Hmm. One minute. Following interim shall remain operative until further order 50% of refund amount pursuant to the impugn order shall be kept separately in a separate account by the appellants. Okay. Remaining 50% shall be deposited by the appellants to the registry of this court. Within 2 months from today, the amounts of deposit may be withdrawn by the appellants on furnishing bank guarantee to their satisfaction of the register, and also understanding that in the event they will be allowed the amount so withdrawn shall be reinstituted to the appellants, allowing 10% separate in the event appeal are dismissed. The appellant shall pay to the respondent 50% of which was kept in separate account and with 10% simple interest from today. From today.
My lord,
This today is
13th, my lord, judgment.
this today is
You have given the
12/7/2000.
13.
Okay, so 50% is to be deposited. But this condition, prima facie, is not applicable in your case.
No, these are, my lord, pending the,
Because that was litigation.
my lord, that's why. But the SSC, my lord, when they found that key refund, they will not.
Yes,
So they agreed to it in this case.
agree to that condition.
Condition.
Then thereafter, your application according to your commissioner's first order
My lord,
was kept pending
my
due
lord,
to the litigation.
my lord.
So far as timing of submission of application, there is no
No
dispute.
dispute,
Manner of submission is not
no
dispute.
disputed. Neither first order nor second order,
Yes, not kept in pending.
my lord,
Okay, only kept in pending due to the litigation.
my lord.
These are the litigation. And their state of Assam was given the condition. You deposit 50,
50%,
they are kept 50% in a separate account. And so far as that 50% kept in separate account will bear interest 10% in the event of dismissal
my lord. From the date of,
from 12/7/2013. That is the condition. So there already money was determined. Money amount was
there is
determined,
no dispute. my lord.
quantified.
The dispute was only whether from court.
So after this first order of the commissioner, which you are supporting, thereafter there was an undertaking from you.
My lord, they took an undertaking the 10% interest on the basis of the same law which was. in the
From
Supreme-
which date?
From the date of the judgment of the Supreme Court.
12/7. 12/7/2013. That is the undertaking taken from you. Okay.
We are not disputing the interest.
Okay. Then
Then following the Supreme Court judgment, my lord, in another case, case 79,
page 79.
the honorable, this honorable court passed the order in another case.
Hmm. Yes. 10% being 50% on a refund amount. File taking an erection from this court to the research and says to permit everyone withdraw an amount of rupees so and so. Being so and so, it was kept in the registry in terms of an order dated 11/3/2002. This was after an interim order of the Supreme Court.
The party got the refund also subsequently.
Oh,
Two judgments I will rely before your lordship, my lord.
hmm.
One is at page 86
86.
and 11 part at page 88, para 3.
88.
Eight.
Yes. Hmm.
In view of these contentions, the question that arises is whether the judgment of this court has been vitiated by any error or law, warranting reconsideration on the behest of some persons who are not parties to earlier proceedings. It is undoubted that they were not parties to the earlier proceedings, but this court has laid down the general principle of law, and therefore whether they are parties to the earlier proceeding, the general principle of the law stands applicable to every person irrespective of the fact whether he is a party to the earlier order or not.
This second order of partially review order was passed when the matter was pending before the government,
Yes.
without anything from the government,
Yeah.
without any seeking opinion from the government.
We don't know that what has happened between them.
No, I don't know, but what is the stand of the?
No, they have not decided that what was happened.
Ah.
But it was forwarded to the government. They have to take the undertaking. Thereafter, they pass the order.
Okay, yes.
Another judgment, my lord, just
Hmm.
2 lines, my lord, I place at page 90.
Hmm.
Relevant part at page 94. Para 13.
Yes.
That is settled law, my lord, your lordship is aware, but
Hmm.
for my satisfaction only, I am placing it. my lord. If they can show, my lord, any order, any provision
Hmm.
in the act empowering the authority to review
Yes.
my lord, in my humble submission, the subsequent order of the Commission of Taxes is actually illegal without jurisdiction. and thereby the same is liable to set aside in cost. And the authority is liable to direct that the amount may be refunded.
There are other cases too, madam. There are other cases too, madam.
Hmm. We'll find out the facts of the case, other series.
This particular case relates to that. The others are for CST.
These are also VAT, that is also VAT. There is no CST because refund is of the VAT.
Yes, only of the.
Okay, the factual aspects,
Actual part, madam.
I'm placing for lots, but I am not running away.
then we'll resume.
The final submission was made, that's why.
I am making submission.
This is final submission in respect of item
This
number,
Yes.
this first item.
First item.
Because the grounds are different. of
Yes,
the-
madam.
all the-
You are moving around.
Hi, Lordship. In this case, we were supposed to file affidavit. So, Lordship, department has requested for some more time. Lordship.
Item number 5, we are hearing. We are hearing it.
Lordship, I will take consent of. Sorry, Lordship.
Ah.
Yeah, sorry, Lordship. Well,
We'll find out at 2. Otherwise, this is not going to be reached, I think, today. We will be rising at 3:15.
some time may be.
We'll find out from the.
Lordship,
Yes.
item number 17, hearing matter. Lordship, the matter may be adjourned for the day.
You are for
Petitioner, Brahmaputra Valley Fertilizer.
Mr. MS
G. Swami,
G. Swami, Learned Counsel appearing for the petitioner has made a prayer for adjournment. Come out with the consent of Learned Counsel for the respondents. The praise the Lord is the case after 2 weeks. Yes, Mr. Sinha, what is your? Yes, yes.
They have to file.
So 12. Yes, MS Devi.
It was issued in 2007, but there is no instruction, Lordship, why they have not released it.
So what will be your prayer? Whether you are filing affidavit or no affidavit?
File affidavit, Lordship, they have prayed for some more time to file affidavit.
How much time?
3 weeks, Lordship.
Hmm?
3 weeks.
2023. Okay. Mr. B. Shinha, Learned Counsel for the petitioner is present. Petitioners. MSLDB, Learned Central Government Council, RDB. Learned Council for the Learned Central Government Council. Okay. Has submitted that communication has been sent for instruction, as the instructions are yet to be received. Has prayed for. Further 3 weeks time to file an affidavit, leaves the case again on. So after 3 weeks for filing of counter affidavit by the respondent. Respondents in deference to the order dated 25/9/2024.
God bless you.
Well, we will also take up item 6.
6. The legal issue is same or what?
Legal issue same here, below the earlier commissioner order is not there,
Hmm.
but I will take your lawsuit below. If your lawsuit looks up below the list of dates, I will take your lawsuit directly to that. Serial number 6 below. All right.
Yes,
Or to 4, my lord. Sheet number 4,
4.
the Supreme Court dismissed the SLP. Referred by the state of Assam, my lord.
12/1/2017.
My lord.
69.
Thereafter, my lord, following the said judgment, my lord, the petitioner wrote a letter to the assistant commissioner submitting its claim for refund for 2012-13 to 2015-16.
Hmm.
Thereafter, the 17/3 to 17 is the judgment of this honorable court. Then 13/9/2019, my lord, 7. The Assistant Commissioner of Taxes, Bagaimgaon, White, letter number so and so addressed to the Commissioner of Taxes, sought for clarification regarding admissibility of the refund claim under section 15B of the CST Act, read with so and so for the assessment year so and so by the petitioner, and requested the Commissioner to issue necessary instruction in that regard.
Hmm.
So, my lord, the Assistant Commissioner sought for the clarification, and the clarification was given on 27/9/2019, my lord. The Joint Commissioner of Taxes Assam wide letter number so and so addressed to the Assistant Commissioner of Taxes with reference to letter number so and so informed that the petitioner was eligible to claim the refund under section 15B of the Central Sales Tax Act for local taxes paid on so and so.
Hmm.
Therefore, 1/10/2019, my lord, the assessing authority passed an order under section 83 of the Assam Value Tax, that is rectification, my lord.
Hmm?
Rectification.
Hmm.
For the assessment year so and so and determine the amount of rupees so and so to be refundable to the petitioner company for the year 2012-13, subject to the claim being made filed by the petitioner. In the said order, the assessing authority noted that section 15B of the Central Sales Tax Act provides for reimbursement of local claim paid on interstate purchase of declared goods, subject to the condition that CST paid on interstate sale of goods. It was further stated in said order of assessment that being agreed by the judgment of this honorable court in so and so, the state government has preferred SLP before so and so, subsequent number as so and so, which was dismissed. It was further stated that clarification from the Commissioner of Taxes Assam was sought for by the office number so and so regarding admissibility of refund claim under section 15B of the CST Act, read with section 50 of the Act. It was further stated in said order of assessment, the Commissioner of Taxes by letter number so and so stated that the dealer was eligible to the refund claim under so and so Act. Now, after passing of the order, my lord, the petitioner submitted its claim for refund of the taxes paid on purchase of raw petroleum so and so. As you also got it, my lord.
Hmm. Facts are different.
My lord,
Facts are different.
facts are different, issue will be the same, my lord.
Hmm.
Thereafter, petitioner, since his claim was not being considered, my lord, pending, the petitioner filed a writ petition before this honorable court. And this honorable court directed the Commissioner of Taxes to consider the application for refund and passed a regent order. Thereafter, my lord, on 3/12/2022, the petitioner received a letter from the Assistant Commissioner informing that the petitioner was
Dr. Saraf, if instead of jumbling all these facts in my mind, if I hear the other side on the first petition, it will be
Well,
better.
if I take your lordship, the impugned order, if your lordship wants to, my lord, what are the grounds for rejection, my lord? Or your lordship may hear the first petition. Thereafter, my lord, we can.
Yes, then after that factual part we can hear.
That your lordship.
It will be better for me
Better, my lord.
to,
Or your lordship may, my lord, hear and dispose of the first petition. Thereafter, we can take up, my lord.
yes, that can
That
be
will be
done.
better, my lord.
No, my lord, the facts are somewhat more related. It will be, my lord, necessary, my lord, if this particular other cases are also gone through.
Hmm?
Because, my lord, finally the impugned, my lord, decision of the authorities which have been put to challenge hearing is almost the same. So that if the facts, simple facts are, my lord, placed, then it will be more convenient for us also, my lord, to
Because my lord, they finally lordship will see in this particular case, in item 6. There is a direction of this honorable court to consider the refund application, and accordingly the order was passed. Lordship may kindly turn to page 94.
I understand. my lord,
That's why my lord, this order was passed by the commissioner again.
No, that fact is that in the other case, applications were pending as part of first commissioner report. When all these litigations were going on, the legal issue, all these were fancier, acquiescence, all these issues he has taken.
My lord.
And those things are up, privacy, I don't know.
It has been taken here also.
Huh?
Yeah.
But whether those facts are also
my
there.
lord, your lordship, my lord, the same things are there. Here also, my lord, after the assessment, immediately I filed the appeal. They are saying that in the Supreme Court, you are not the party. Secondly, he's saying that we are active.
Okay, let us read that order, then
Lordship will see the one, it is in item 6, lordship may see the impugn order. The facts will be clear.
Yeah, yeah.
no, here there is no order, earlier, previous order of the commission.
No, they know.
Yes.
The lordship, you see page 99. my lord.
This is the order of the commissioner.
I'm reading
Or
from
like the
Commissioner.
previous order. Yeah.
Earlier, there was existence of a previous order of a statutory authority. The question is whether power of review is available. Here is not the issue.
Lord, I'm not.
That
that's
is
why-
one of the legal issue there,
That's why I
which
submitted-
you will address.
No, that's why I
But
submitted
that issue is not to be addressed here.
the review question will not arise here.
Yes, that is what I am saying.
Absolutely, my lord.
Facts are quite slightly different there.
Then lordship can hear the other one.
Huh?
If that is the valid point, then yes, it can be heard. The first one can be completed.
Yes, I am quite, now
Same it is stressed.
facts are clear in the first case.
I think it will better, my lord, if your lordship first case is disposed of.
No, not disposed of, lordship will
No, no.
hear it.
Okay, we'll decide, we'll leave it to
And
me.
this case also will be decided. There is nothing
Leave
like
it to me, but if you can address on that first issue, then we'll continue with that, but I have to be,
that. My lord, let the first case be, my lord, first.
if possible, you can start addressing it. We can deal the judgment commonly, maybe, but
I have no problem at all. I will.
you just prepare all the
I will prepare one list of dates. etc.
list of dates for all the 6 cases
I will-
together.
I will.
Since similar kind of order,
In the chart type, I will prepare.
yes. Otherwise, going through all the files,
I will
preparing the
prepare for
draft.
The convenience will also, because the chart type earlier also I prepared for this case.
So
Once we make
that,
the submission on these cases, except review, all will be similar.
আগত হয়ে লিখুন। Yes. Mr. Gogoi, otherwise spoke
My lord.
in all its forms.
Lord.
And raw petroleum coke, calcine petroleum coke, that issue is settled.
Already said. No dispute regarding that.
So no need to address on it because by virtue of various decisions, it is settled.
My lord. In fact, my lord, prior to my lord, the issue being raised before this honorable court, it was already a settled issue by the Supreme Court, honorable Supreme Court.
But
Prior
still
to-
litigations are
went to the-
going on.
They went to Supreme Court again and challenged them.
Some point was raised, my lord, but it was not appreciated.
Because state of Bihar raised issues,
Yeah.
it went to Supreme Court again. Yes.
My lord, here the relevant part will be, my lord, page 18, page 154,
150.
the reassessment order. On the strength of which the petitioner now claims that, my lord, he is entitled for his part. And not, my lord, pursuant to the letter which they address as a, my lord, order of the Commissioner of Taxes. At page 198, that's not the order.
Yes.
Yes, page 154.
Hmm.
Lordship will see the date, my lord, is 12/6/2018 for the financial year 6 and 7. And my lord, serial number 10, section and subsection under which the assessment made under section 42 of the ABET Act 2023. Now, 2003. Now, my lord, it has been admitted by the other side today also, in fact, on the earlier occasions too, that my lord, this assessment should not have been done under section 42. Because it has been fallen, it has fallen from the mouth of the other side today also. Yes, my lord. Lordship will kindly note it, my lord. Because this assessment has been done, my lord, under section 42 of the VAT Act.
Under
42. Section
42.
Serial number 10, Lordship may kindly mark it in the order.
Mhm.
Section and subsection under which the assessment made is, it is under section 42.
154.
154.
Hmm.
Serial number 10 is the relevant section under which this order was passed. It is section 42 that has been mentioned.
Hmm. What is 42?
42 minus.
Yes, 2 million in compilation.
Forty-two is the power of reassessment in certain cases.
Hmm. So,
It says
for
that
exercising power under 42,
where any court or the tribunal passes an order in appeal or division to the effect that any tax assessed under this act or the central act should have been assessed under the provision of a law other than that under which it was assessed, then in consequence of such order, or to give effect to such finding or direction contained in such order, such turnover or part thereof may be assessed or reassessed, as the case may be, to a tax at a time within 5 years from the date of such order, notwithstanding any limitation period which would otherwise be applicable to the assessment or the
how
assessment made.
it can be passed under 42?
Cannot be, because when it says, my lord, if a particular assessment has been made in a wrong provision, Lordship will see, should have been passed, assessed under the provision of a law other than that under which it is assessed.
Order in revision to the.
Should have been assessed under the provision of a law other than that under which it is assessed. Then in consequence thereof, if a order is passed. In a wrong provision, if a particular assessment.
Oh,
is
no, but condition precedent should be a tribunal order
Yes,
or a
there- yes,
court order.
yes.
Now, where is the existence of?
That's why, my lord, ultimately, there's a case, my lord, in the orders passed by the commissioner now, my lord. That's then we have taken.
Hmm?
So, my lord, may I proceed, my lord, in this? In this
Okay, 1
particular
minute.
assessment order at 154. There is a ground in the order passed by the commissioner now, which is impugning the present petition.
Right. Hmm. Okay, read.
The dealer has submitted petitions of on 26/4/2010 for refund of amount of so and so, along with only for the assessment year 2006 and 7. My lordship will find this. Lordship may kindly have a look at this also. Page 56. The refund applications were there in 2010 itself. Page 56. Here, my lord, in the present petition, lordship is dealing with, my lord, financial year 2006, 7 to 13 and 14. So all these refund applications are there in the petition annexed. my lord.
Hmm.
So applications were there.
It is recorded 26/4/2010.
Verification of the case records revealed that so and so, lordship, here I am not making any submission, my lord. Lordship may kindly turn to page 155, para 3. Completion of audit assessment. There was an assessment on the part of the petitioner. Thereafter, there was an audit assessment. They have submitted their, my lord, return, and there was an audit assessment. That page para 3.
Hmm.
The audit assessment of the dealer for the year 2006 and 7 was done by the Deputy Commissioner of Taxes, Tinsukia Zone, on 10/3/2012. The assessment order is, however, silent on the reimbursement under section so and so of the SWOT. So this assessment order, though applications were pending, it was silent about that final refund application or refund claim made by the petitioner.
Hmm.
And my lord, there was no challenge by the petitioner at that point of time that despite my lord, my refund application being pending, how this audit assessment was made for the entire amount without making the refund. On that point, my lord, the impugn order, we have, the commissioner stated that, my lord, this particular audit assessment has attained finally. Because you never challenged it. There is an application pending, but despite that, the audit assessment was made. And without giving the refund or without even considering the refund, the assessment was audited. So on that point itself, there was a ground for challenge, my lord, if they are not satisfied with the audit assessment.
This audit assessment is done by virtue of which
Under
power?
Section 36.
Hmm?
Lordship may see, my lord, 36. If Lordship is holding this book, my lord, it is 335.
The comparison with page 21 also.
And Lordship will also have a look at the rule 29 also.
It's 15.
Page 40, paragraph, section?
My lord, section 36,
Section 36.
audit assessment.
Section 36. Page.
Page, my lord, 335.
Huh?
335 of this particular book.
Assam Railway Tax.
Yes.
Section 36. Hmm. Section 36.
Yes. Where a registered dealer is selected for audit assessment file. Now, Lordship will have to see the rule 29. Rule 22, I'm sorry, madam, rule 22. At the same time. Regarding audit assessment.
Let us read 36 first.
Yes, where a registered dealer is selected for audit assessment by the prescribed authority on the basis of any criteria or on random basis. This is usually when under 36(1)(a) is done. The prescribed authority is not satisfied with the correctness of any return filed under section 29 or bona fides of any claim of the exemption, deduction, concession, input tax credit, genuineness of any declaration, evidence furnished by the registered dealer in support thereof, or the prescribed authority has reasons to believe that detailed scrutiny of the case is necessary, or a provisional assessment under section 34 has been made. The prescribed authority may, notwithstanding the fact that the dealer may already have been assessed under section 34 or section 35, serve on such dealer in the prescribed manner notice requiring him to appear on a date and place specified therein, which may be in the business premises or at a place specified in the notice, to either attend and produce or cause to be produced the books of account and all evidence on which the dealer relies in support of his returns, including tax invoice, if any, or to produce such evidence as specified in the notice. For this purpose, the prescribed authority may also undertake tax audit of stock in trade of the dealer. The dealer shall provide full cooperation and assistance to the prescribed authority to conduct the proceeding under this section at his business premises. If the proceedings under these sections are to be conducted at the business premises of the dealer, and it is found that the dealer or his authorized representative is not available or is not functioning from such premises, the prescribed authority shall assess to the best of his judgment the amount of tax due from. If the prescribed authority is prevented by the dealer from conducting the proceedings under this section, the prescribed authority may demand a sum not exceeding the amount of tax so assessed by way of penalty. The prescribed authority shall, after considering all the evidence produced in course of the proceedings or collected by him, either A, confirm the self-assessment made under section 35 or set aside the self-assessment under 35 and assess the amount of tax due from the dealer, or assess the amount of tax due from the dealer if no assessment has been made under section 35, provided that if the prescribed authority proposes to rely on any evidence collected by him, the dealer shall be afforded a reasonable opportunity of being heard before any adverse inference is drawn.
Rule 22.
Rule 22, yes, page 57. audit assessment.
Yes.
The following categories of cases may be taken up for audit assessment under section 36.
Hmm.
Here, one is for a gross turnover exceeding 5 crores rupees in a year.
Hmm.
Claim of input tax exceeding 10 lakhs rupees in a year. Claim of refund, my lord, this is important. Claim of refund exceeding 1 lakh rupees in a year. So there will have to be an audit assessment for refund. If moment there is a my lord, claim for refund, there will have to be an audit assessment. Claim of sales made in the course of interstate trade and commerce, or in the course of export of goods out of the territory of India, or in the course of import of goods into the territory of India exceeding 20 lakhs rupees in a year, 25 lakhs rupees in a year. Fall in gross turnover or payment of tax compared to last year. Claim of sale, purchase or consignment of goods not matching with the other party to the transaction. Exceptional cases in which ratio between purchases and sales, or between input tax and output tax, or between stocks and sales is way out of the general trend in the trade or industry.
So it apparently Roman 3 and Roman 4.
Yes, ma'am.
Roman 3 and Roman 4. Claim for sales in the course of interstate trade and commerce also
3 and 4 also, yes.
25 lakh rupees.
Yes, ma'am.
Yes. Let us see down the order.
Yes, ma'am. Next is madam, filing of writ petition against 4, see, para 4. Filing of writ petition against rejection of refund by government in the meantime. The government of Assam, while later dated 25/9/2008, rejected the refund proposal of Guwahati Carbon Limited for the year 4-5 under the AGST Act so and so, giving detailed reasons thereof. On the basis of such communication of the government, the Commissioner of Taxes Assam, while later dated 2/7/10, rejected the refund proposal of Brahmaputra Carbon so and so for 2004 and 5. Being aggrieved, the dealers approached the Honorable Guwahati High Court by way of filing of the petition number so and so. The verdict of the Honorable Court in favor of the dealer. Honorable Guwahati High Court allowed a petition holding that the Honorable Supreme Court in the case of State of Bihar versus Universal Hydrocarbon Company 1994 supplementary so and so has already held that RPC and CPC are same, and hence the controversy need not be entered again. Finding of SLP by the state and dismissal of the appeal. Being aggrieved, the state government filed SLP before the Honorable Supreme Court. Subsequently, renumbered the so-and-so. The Honorable Supreme Court in SLP so-and-so passed an interim order on so-and-so. Finally, the Supreme Court in the renumbered SLP number so-and-so dismissed the appeal filed by the government of Assam. Resultantly, the amount of tax paid on purchase of RPC stands reimbursed to the dealer. Industrial concession. The dealer claimed that the activity of conversion of RPC to CPC is a manufacturing activity, and accordingly the dealer applied for tax exemption incentives available to the manufacturing unit. On the basis of this application, the dealer was issued an eligibility certificate by the Industries Department by so and so. The said EC granted tax incentive for a period of 9 years from so and so, subject to the mandatory sealing of so and so. On the basis of the said eligibility certificate, the certificate of entertainment was issued by the Swarna Taxes Tinsukia. It is valid for so and so, and the said CE was renewed up to 2011. March 2011. The unit again undertook expansion and made an additional investment of so and so, and the unit was granted a further eligibility certificate under the pipeline units order dated 2008 for tax remission from 11 to 18 for rupees so and so. During the period of remission, the dealer is supposed to charge and collect the tax amount, but it can avail the benefit of remission of 99% of the tax so collected and required to be deposit only 1%. And this was the assessment. Now 9 says, my lord, interstate purchases. The concerned refinery has submitted statement of tax deposition under the VAT Act in Annex 1 and the statement of VAT amount paid by the Digboy Carbon Private Limited during the period in Annex 2. This has substantiated the payment of VAT by the dealer at the time of RPC purchases, sale/turnover. As per the case records, the main purchaser of CPC are so and so, and the entire sale was made in the course of interstate trade and commerce. Now, my lord, 11, 157, it says, my lord, the grounds of refund. the tax paid of purchases has been claimed as refund by the dealer as per section 15B of the Central Sales Tax Act 1956, where any tax is levied under the law on the sale or purchase of any goods referred to in section 14 of the Central Sales Tax Act 1956, and such goods are subsequently sold in the course of interstate trade of commerce, the amount of tax paid under the local law is refundable to the dealer paying such tax. The dealer purchased raw petroleum coke from refineries by paying VAT during the relevant year and sold the same after converting the same into calcined petroleum coke, which is the same declared commodity, namely coke in all its form. The Supreme Court, Honorable Supreme Court, in the case of State of Bihar versus so has upholding the judgment of the High Court Patna and held under exact facts that the local tax is to be reimbursed or refundable. Now, Supreme Court by then order dated so and so dismissed the appeals filed by the state. Hence, the decision of Supreme Court fully supports the respondent or dealer. Now, Lordship will see the ground under how many under 42 it has been assessed. The last line. The Honorable Supreme Court by then order in 157 Melody is trying to justify under section 42. The Honorable Supreme Court by then order dated 12/1/2017 dismissed the appeals filed by the State of Assam and others against the Guwahati High Court's order dated so and so. Hence, the decision of the Supreme Court fully supports the respondent dealer. In view of the Honorable Supreme Court's judgment, I proceed to assess under section 43 of the VAT Act 2000.
1 minute. 1 minute. Who is the authority here?
Madam, the authority is the Assistant Commissioner of Taxes in India. Under 42, he has exercised this one particular. Executed the assessment and has issued this particular assessment order. And declared that the petitioner is entitled for a refund of 50,81,450 under the wrong provision which is beyond his jurisdiction, my lord.
Come to the page 199 again.
My lordship will see, my lord, 198 first. All along, my lord, the petitioner has been submitting that this is the order passed by the Commissioner of Taxes. Whether this is an order, it can be termed as an order.
No,
This is a
no, before
communication.
that, 199,
My lord,
last paragraph.
completion of CST
The
assessment.
audit assessment of the dealer for the period was done by the
No,
Deputy
this is the
Commissioner.
2012,
Huh?
the first assessment. And in under 42, my lord, it was reassessed again.
Where is
That's
the
what-
occasion for reassessment?
That's what, my lord, that has been stated by the Commissioner of Taxes
Hmm?
in the impugn order, which is impugn herein, my lord. Lordship, that's why I pointed out, Lordship may kindly mark it, page 155, para 3. Paragraph 3. Assessment, completion of audit assessment. It was already done, my lord. The audit assessment of the dealer, that is the petitioner for the year 2006 and 7 was done by the Deputy Commissioner of Taxes Tinsukia dated 10/3/2012. The assessment order is however silent on the reimbursement so and so. Now Lordship will again turn to page 154. The dealer has submitted petition for refund on 26/4/2010. That's what we have been repeating. Page 154. Immediately first line of the order. The dealer has submitted petition of 26/4/2010 for refund amount of so and so only for
No,
assessment year.
no, again come to 199.
My lord. 99,
199,
my lord.
3,
Yes,
12/3/2012.
my lord.
Now turn over the page.
10/3.
12/3/2012.
Right.
Audit assessment. Here it is 10/3,
It is 12/3. My lord,
12/3. No, turn over the page.
my lord, in page 155 or?
No, 199.
My lord,
Turn to page 200.
200.
As per assessment order,
Order, yes. The
amount reimbursable under 15B of the CST Act 1956 for the year stands at rupees 34,22,010 and the assessing authority has allowed interest at rupees 10%, amounting to rupees 16 lakh. So what is that?
But this is the, my lord, that's why I'm saying, well, this is not an order of the Commission of Taxes. It is
Who?
directly in, my lord, in
Which
page
one?
198. And my lord, this is 154.
No, he is mentioning about that assessment or audit assessment done by Deputy Commissioner of Taxes.
My lord.
This is thereafter, oh.
No. He is
No,
talking about this.
no,
my
no,
lord.
no,
Page
1 minute.
157.
Oh, pages are,
157.
I'm sorry. These pages are somewhat, Mr.
It's same, my lord, that's mine.
No, in my read petition, it is different.
My lord.
After page 2, 199 is page 2 of the order, internal page. Then it goes to internal
Oh.
page 3 has been annexed.
Oh, it page, in a page 201.
I've been reading like that only. Mr. Have you seen?
Yes, my lord. From my lord, para 3 goes down.
I am reading.
Para 8. So that's why, my lord.
No, I have been reading like that only.
I was also wondering, my lord, how there can be such a.
No, you are not wondering, you are just after the.
No. Now I was reading like that.
Well, I've just go through it, what is the mistake?
Oh, I have been reading only and I'm memorizing it.
That's why I was wondering how they.
198.
200 page. 81 of my para 8 and 4. 83.
3 was episode 2, I think.
I was memorizing it like this page 200 that 50 lakh 81,000 is part of 2012 assessment order.
Well, I'm really sorry, this is 201 should have come to as 200.
It will change to I was reading like that only. দুশ একটো দুশ হব আৰু দুশটো দুশ এক হব
201 will become 200.
200 and 200 will become 201. But I thought that this part was part and parcel of that audit assessment order dated 12/3/2012. That's
No, this is a part of the subsequent order.
It's part of para 7.
No, I understand.
but I was reading like that only. Part of paragraph 3.
Yes. In fact, my lord, when the.
And that is why I have been questioning you time and again. I was reading like that only.
Your lordship will certainly will not, because the pagination is wrong. So
My thought process has been disturbed now.
I am sorry for that.
Yes, I'll try. So, what do you say? There's 1 minute. I'm just reading again. Let me reconcile.
Page 199,
Nature
para
of-
3 and here.
1 minute. Repetition, verdict, SLP. Order digit. $25 10. $12 3. Yes, person. This assessment order means this order.
Pursuant to the honorable.
Page 200,
Yes.
the first three word, as per the assessment order, is that order. That page at 12/6/2018 order.
Yes, sir.
Okay. Who is this authority? Assistant?
Assistant Commissioner of Taxes.
Hmm.
And my lord, this letter is of the Commissioner of Taxes, Assam to the government, seeking my lord the sanction for the my lord refund. It's not an order. Page my lord 202. Lordship will see at page 202.
No, this is after assistant commissioner, it reached deputy commissioner.
There is the,
Page 200,
yes,
page 200, paragraph 8. SCT Tinsukia being satisfied the refund proposal forwarded the same to the DCT. And DCT being satisfied the refund proposal forwarded to the concerned ACT has forwarded the same to the Apex office.
there is a Commissioner of Taxes. office.
Huh.
Commissioner will have to now my lord, because when it is more than 50 lakhs, he will have to move the government. Even the
Right.
commissioner doesn't have the power.
Yes.
He can
Now it
only-
reached the level of commissioner.
Yes,
Then by this order, 25/10/2019, it was forwarded to the government.
it's not an order, my lord. My humble submission, it cannot be termed as an order. my lord. That will be a wrong, my lord, term.
Okay, what is the meaning of order then?
But this is a letter, communication.
Oh,
He cannot
wow,
order the
yes.
government that.
At various stages, I'm just
My lord.
understanding the concept.
my lord, yes.
Statutory authority, these are statutory authorities. Assistant Commissioner is a statutory assessing authority.
Lordship.
Deputy Commissioner also, as per Rule 29, and Commissioner also. Now, statutory authority passing an order, passing a letter, issuing a letter by your connotation, exercising a power,
My lord, yes.
has issued a letter for prior approval and sanction under order 29, Rule 29.
29, yes.
Letter, okay, letter, let us take it as a letter. But exercising statutory power under Rule 29,
Yes, he is the authority, we can.
exercising
at least
statutory
proclaim it.
power.
My lord, yes.
So, under 29, he has forwarded for prior approval.
Yes, he has forwarded under 29, but my lord, it's not a order to say that this will have to be given.
Okay.
My lord, because my lord, the.
Okay, the question now, that is why the question is that it has gone up.
Yes, that is the authority.
It has gone up. Now, Commissioner, next time, by his successor in office,
Lordship,
successor in office perhaps,
yes.
he tried to make it parallel. It has gone up by this order, 25th October 2019.
Lordship,
Prior sanction, prior approval and sanction.
my lord,
And by the order or letter, as Mr. Gogoi's version, the successor in office, who is also a statutory authority,
Right.
he is trying to make it parallel and questioned the letter written by the predecessor in office
yes.
and nullified virtually the letter.
My lord, one thing,
Because he rejected everything.
probably my lord, this order was passed, that's why I wanted to point out that my lord, there is a series of cases which have been listed before his honorable court. The numbers are there in the other cases which are listed today. That my lord, the refund applications are pending, we are sitting over it. and there should be a direction to immediately refund the whatever amount is due to the petitioner, pursuant to the Honorable Supreme Court's direction. While considering that writ petition, the Honorable Court directed the Commissioner of Taxes to consider the refund applications and to pass orders.
No,
Only during that part.
No, Mr. Gogoi, consider with certain observations it means different thing, and consider simpliciter means different thing. Here is a case, not a case of consider. That is why I try to bifurcate the other cases.
Yes, yes, but there is no order here.
When I saw that particular thing, that another writ petition was disposed of
Yes.
in respect of other cases,
About 5 cases.
directing the authority to consider.
Right.
But here is not a case of consider.
So that I will have to examine. I was also, my lord.
See, this is
has come to my
this is the difference.
So there is an order. I know.
So that is why, in the hindsight, I
But
say
one
that
thing-
let us keep that.
It's not there in a affidavit. Even then, Lordship may kindly have a look at my lord, the provision of section 80. But there is a power.
Okay, first on the review power. Because successor,
No, this is not a, yes, review power is there. That's why I'm saying.
194, he also pays also your loss. Page 194.
It's a revisional power, my lord, page 82.
194 is your undertaking.
It's sought for by the department.
You acted on that.
That's why I'm saying below
No,
that.
there is no dispute on that.
No, I'm
No,
I'm not
no,
saying that.
Oh, yes.
that regarding the other 6 cases,
Not this is the different case. No?
this is different.
So page
This
194.
has proceeded on different footing.
194, they say that you kindly give the undertaking for eligible. Your lordship may just read. No?
You're proposing something by
This
this.
is on the basis of the
The other case is different. This is slightly different.
this is on the basis of the LR opinion, my lord.
Huh.
The government sought for, on the basis of that, they sought for an opinion. I mean, and
That is why I am asking Mr. Gogoi just to
Yes, yes.
leave aside other cases. By the commissioner order, by letter, it went up. And there was some deliberation with LR and all.
Subsequent development may I, my lord.
And,
Yes.
and this letter also in 20 September, this was you give an undertaking. Something was
No, yes, something was. going on.
peculiar to this petitioner.
Yes.
I'm not saying about other cases, leave aside,
So
don't.
far as these assessment years are concerned, my lord, which are part of the petition, even here also, my lord, some proposal was moved, it went to the government. Government is the authority who can give the.
Prior approval.
No, yes, prior order sanction for my lord refund. That was pending, my lord. At that point of time, some opinion was sought for from the Advocate General of that point of time.
By the government.
You go by the department, my lord, say
Page
finance
242,
taxation
my lord.
department.
page 2,
And again,
Huh?
my lord,
page 242.
the views of the LR was sought for.
Yes.
Thereafter, my lord, matter was lying there, my lord, and again the file, my lord, came to the my lord, present Advocate General, my lord, Assam, for opinion. And the opinion was again furnished, my lord, and subsequently, my lord, this is the speaking order. Or I would say, my lord, Lordship may kindly turn to my lord, section 82 of the my lord, VAT Act. Even today also, we have got the power. To my lord, 82, my lord, Lordship may kindly have a section 82 of the VAT Act. Because the order is of 2018. And the reassessment order. Revision by the commissioner. The commissioner may, on his own motion, call for and examine the records of any proceeding under this act. And if he considers that any order passed by any authority subordinate to him is erroneous, so far as it is prejudicial to the interest of the revenue. Well, here, my lord, that reassessment order is prejudicial. May, after giving the dealer a reasonable opportunity, heard, pass such order as he may deem fit, provided the commissioner shall not pass any order under this subsection after expiry of 8 years from the end of the year in which the order sought to be revised was made, my lord, the revisional order is of 2018. We have got 8 years till 2026.
Which order you are reviewing?
Well, here, my lord, the whatever observation has been made in the impugn order has been made against that, my lord, reassessment order of 2018. Whereby, my lord, suddenly there was a U-turn, and my lord, the order was passed in favor of the petitioner by relying of certain judgment which was passed by the Honorable Supreme Court, taking recourse to section 42 of the VAT Act. Of course, you will see, my lord, how, my lord, they are trying to give relief to the petitioner, even by applying a wrong provision, that is section 42. Not only this, my lord, you will see the other series, the other cases in the series, my lord, there also, my lord, there is a wrong provision being used. Deliberately or what, my lord, I don't know, but to give relief to the petitioner.
Vishnu also intensely wanted to give relief. Deliberate.
What it appears, my lord, from the action.
Where is the assessment order dated 10/3/2012?
Comparison.
That is fixed, yes.
Dr. Sir, why this is not 18, why this is not?
No, because this was not relevant. Because this was not relevant, that's why your lordship, when you wanted to look into it, we have given by comparison.
Hmm. Hmm.
After my learned friend makes the submission, I will satisfy your lordship that what is the audit assessment, why it is not relevant, I will make submissions.
Yes.
Let him complete, after I make submission.
So you have power under 82.
Otherwise, we have, but my lord, this nowhere is mentioned that, my lord, this is a order of revision.
No, I am recording your submission. This,
Otherwise,
you have
there-
power under
there is a
82.
provision under- For revision under 82.
And this assessment order,
Lordship. But my lord, my
assessment order dated 12/6/2018
Yes,
is bad for what? Why?
because my lord, it has been, my lord, passed under a wrong provision
Bad for passing it
under section 42.
under a wrong provision,
Wrong, there is section 42.
wrong provision.
Just to, my lord, evade the limitation period, my lord, for the assessment.
Section 42.
Because here, my lord, again, my lord, limitation period extends to 5 years.
But the application that is not denied, that the application was for refund.
Yes, no, there is no dispute regarding that we have-
Application was for refund within due time.
within the-
Now only that submission is that the prior so-called assessment order passed in 2010
Yes,
did not deal with
yes.
the matter of refund.
And my lord, nowhere it is mentioned that, my lord, that part will be considered later on when the order will be passed by the Honorable Supreme Court or the Honorable High Court. That the issue is pending therein. As my lord mentioned in the order, in the letter of the, my lord, Commissioner of Taxes, at page 199. There, my lord, he has justified that, my lord, for that reason, since the issue is under session before the Honorable Court, the refund applications were not considered. Despite, my lord, same being pending before the authorities, but there is no such observation or, my lord, any remark in the assessment, which has now been placed in the compilation under section 36(1). Because it will have to be supported by something, because today the assessment orders are before the Honorable Court. You say that, my lord, it was kept in abeyance.
Okay.
Now, lordship will see the,
Without disturbing my learned friend,
yes,
without disturbing my learned friend. My learned friend is appearing on behalf of the Commission of Taxes. Lordship, I'm just pointing out, he is appearing on behalf of the Commission of Taxes. The affidavit in opposition has been filed by the Additional Commission of Taxes.
on behalf of authorized.
I will not disturb you at all. I'm only making submission, my lord, that he is appearing on behalf of the Commission of Taxes. He is justifying the order of the one Commission of Taxes, whereas the another Commission of Taxes order, he says, my lord, that these observations have been made which are not there. The affidavit in opposition which has been filed is by the Additional Commission of Taxes. I'm just pointing out, I leave it on that one.
Because these are part of the record of the office records. my lord. This speaking order, whatever is there, my lord, in page 238, it's part of the office record. my lord. I will clarify on that part. They cannot be concluded. So I will, my lord, on the next day, I will clarify as to why he has passed. Because in other cases, there are orders of the Honorable Court. So he has passed an order. Here also, my lord, on what authority? All of a sudden, his order was passed. Because there was a direction he had to follow. But so far as this case is concerned. Now, my lord, may I point out the, my lord, order of the, my lord, which is impugn herein, my lord. Otherwise, my lord, this is the sum and substance of the entire case. You only have to see the justification given.
Yes.
Yes, my lord, page, my lord, 238. Lordship will see, my lord, my lord, number 2, para number 2. Finality of audit assessment made by the Journal Deputy Commissioner of Taxes for assessment years 2006 and 7 to 2008 and 9. There, my lord, till 2014, separate, my lord, assessments were made. So the dealer has claimed reimbursement of tax paid on purchase of raw materials, that is raw petroleum coke, in terms of the provisions of section 15B of the CST Act, whereby section 51 of the Assam VAT Act 2003. The matter is referred to the Journal Deputy Commissioner of Taxes, Tinsukia, for completion of audit assessment specifically mentioning about the refund. Lordship will kindly note this, madam. Specifically mentioning about the refund reimbursement claim for VAT paid on purchase of RCP. So it was referred specifically, madam, that you will have to consider the refund.
Hmm?
Lordship will see this particular, madam, para, last line of the para 2. The matter was referred
Hmm.
to Zonal Deputy Commissioner of Taxes, Tinsukia, for completion of audit assessment, specifically mentioning about the refund.
Hmm.
Reimbursement claimed for VAT paid on purchase of RCP.
Hmm.
The Zonal Deputy Commissioner of Taxes, Tinsukia, framed the assessment under Central CST for the period so on 10/3/2012. However, the assessment orders did not.
Wherefrom he has derived a view that he did not allow. It was silent.
It was silent.
He cannot say, put a something word in the order of the Deputy General Commissioner or whatever, that did not allow. He was silent.
But here, my lord, then again, my lord, in the,
You cannot read something.
which is not there in the order itself.
Where is the order? Show me. Did not allow. He is reading something into an order. Where is that?
My lord.
If I have read with you only
Yes, yes.
the other order, which is a part of the compilation, where is that did not allow? There was a confusion in the field at that point of time. RPC, CPC, same thing or other thing. And if he goes, he will invite contempt also.
No,
The
at that point of
Deputy
time-
Commissioner, perhaps wise sense prevail upon him. Let me be silent. Could be, I don't know, I cannot go into the mind, but it is not that he did not allow. He remains silent.
Yes. But
That is the fact of the matter.
yes, apparently now from the record, it is apparent that, my lord, there is no whisper about the refund.
No
But, my lord,
whisper.
it was not considered.
So
But that's
basically, asking him to decide on a point,
But he-
that
he-
authority
he remained
decided to maintain silence.
My lord.
Whatever lordship is observing now, exactly the same, in the opinion it was given, that it has not been rejected, page 247.
Okay, let us read
No,
further.
exactly the same thing.
My lord, the opinion of some.
I'm not saying,
legal
we are,
authority
uh,
cannot be a part of the
now,
petition
you
as an
see,
annex.
now it is the opinion, the
Opinion
is the
should not have been
government.
annexed, my lord.
I'm just supplementing. I'm not,
Ultimately, they have annexed it, my lord.
Okay.
yes, we can annex it nowadays.
Wow, where is the?
Everything is now available.
However, the Zonal Deputy Commissioner of Taxes, Tinsukia, claimed the assessment order under so. However, the assessment order did not
Yes.
allow the claims of so. Were referred so. Now, on the next para, the dealer did not challenge the assessment orders made by the concerned Deputy Commissioner of Taxes, Tinsukia zone, and did not file any statutory appeal revision for not allowing the reimbursement of taxes paid on purchase of RCP. It means that the dealer had accepted the assessment orders. Therefore, the assessment orders passed by the zonal DCT had attained finality after expiry of the period for appeal or revision as provided in the VAT Act. The pendency of other proceedings cannot be ground for non-challenging the assessment orders. So here, otherwise also, my lord, it was not considered. They were aware of that, my lord. Despite having a claim, they ought to have, my lord, immediately, even if, my lord, say, my lord, not preferring a review or appeal, they should have represented that, yes, despite this audit assessment being made, my refund has not been considered. So they should to remain silent, same, like that of the order.
So, according to a commissioner, he was pen-sitter.
Yes, have to be, because when someone is fighting, someone has got the release, that's a different thing, but from day one, from 2010, you were sitting silent. And suddenly, when the order came in favor of a particular party.
So, it all boils down to page 238, third paragraph and fourth paragraph.
Yes. Third,
Third is the Zonal Deputy Commissioner did not allow,
my lord.
and the Commissioner's
Then also
interpretation.
The authority, whether under section 42, their reassessment order in favor of the petitioner, that too on a refund, my lord, application or the refund demand pending, my lord. whether under 42 that can be done or not, my lord.
Okay, let us read further.
Then, my lord, so far as the other part is concerned, already
Paragraph
read
3,
out.
finality of audit assessment. Paragraph 3 of the order.
Yes. Finality of the audit assessment made by the Superintendent of Taxes Tinsukia for assessment year so and so for the period 9 and 10 to 13 and 14. The dealer claimed reimbursement of the tax paid on purchase of raw materials, that is raw petroleum coke, in terms provision of section so and so so and so. The audit assessment for the assessment year 2009 and 10 and assessment year 2010 and 11 to 13 and 14 were made by the Superintendent of Taxes Tinsukia under CST Act 1956 on 3/3/2015 or 3/9/2015 respectively. The assessment orders passed did not allow reimbursement of tax paid on purchase of raw materials claimed by the dealer. Dealer did not challenge the assessment orders made by the Superintendent of Taxes Tinsukia zone and did not file any statutory appeal revision for not, and the other is same.
Okay, same. Then paragraph 4.
For subsequent Honorable Court's order, the subsequent development that the Honorable Supreme Court finally dismissed the appeal. And my lord, the order of this Honorable Court stands.
5.
5, reassessment by the Eastern Commissioner of Taxes. Here, my lord, the jurisdiction of the, my lord, for reassessment under section 42 has been, my lord, questioned, and it has been replied that it's totally wrong, my lord. Would not have been done under section 42. May I read this, my lord? Based on the Supreme Court's order dated 12/1/2017, the Assistant Commissioner of Taxes Tinsukia took up the cases for reassessment under section 42 of the Award Act 2003 and passed the reassessment orders allowing the refund amounts along with the interest.
This Assistant Commissioner of Taxes Tinsukia was asked by anybody to take up the cases.
But that, my lord, yes, that, my lord, will have to see the records. But otherwise, my lord, all of a sudden, how he could have passed that order? I will place that, my lord.
It is up to
Because,
you.
yes.
You are
Yeah,
not
I
placing till
understand that.
date.
I will.
You are not placing
No,
till date.
But since, my lord, the query has been raised, I will definitely satisfy.
It is up to you, but it is not reflected.
Some might be some.
And apparently, otherwise, the views of the commissioner, earlier commissioner,
all-
that it kept pending. Because otherwise, the assistant commissioner has taken up the cases
My lord.
for reassessment after the Supreme Court verdict. It transpires. He has not been asked by any external authority. It is not said.
My lord.
I'm posing this
Yes,
to
yes,
you.
might be,
Then
my lord.
continue.
There's a probability.
Then thereafter 42 years, we can do that. Then past reassessment order, allowing the refund.
My lord.
Refund were forwarded, Deputy Commissioner, Assistant and DCT satisfied. DCT again satisfied.
Well, not only DCT, my lord, even the commissioner was satisfied, he forwarded the proposal to the government, my lord, by that letter in page 198 or 91. So that,
No.
at that point of time, my lord, all was in favor
The
of the
question
commissioner.
is, right,
Yes.
if you relate the source to 82,
Lordship. No, no, yes,
if you relate the source of power to 82, then it is subordinate.
yes,
But here is a case in between satisfaction reached by the Zonal Assistant Commissioner and Zonal Commissioner and the impugn order herein. It was intervened by another
then the commissioner of tax.
interference
Detail.
by the Commissioner of Tax.
So there has been reply, my lord. May I proceed?
Yes, reply.
Well, 6, my lord, page 240.
Yes.
The relevant provision of the VAT Act 2003 under the reassessment was made.
That is the question.
No, Lordship will see.
He said it wrongly.
Well,
But how can he sit? This is sitting in appeal.
no, it has been my lord stated. I will point that. Because, my lord, it's there probably in the affidavit we have stated that, my lord, since, my lord, the commissioner has no say in a refund application when it is more than 50 lakhs. He is not the authority even.
What is there during break? I was looking at some other thing.
Lordship.
Then I came across, I just now it will be relevant. Whatever is there in the order, then you cannot supplement by anything, right from Mohinder Singh Gill, right from Govardhan Das Bhaji. So whatever is there in the order. You cannot supplement it by anything by affidavit. So this,
No, not supplementing, but there's a fact, my lord, from the provisions of the act itself is shows that the commissioner cannot, my lord, sanction it, my lord. He has no authority. He
yes,
can only propose.
I can understand.
Because
If-
he is the authority, you can forward.
While deciding on the prior approval, government interferes with the commissioner's letter, earlier letter. I can understand easily.
No,
to
then I will play that, that's why I'm saying, my lord, I will place the record to show that, my lord, how this order was passed. Probably, my lord, the government has asked him to take a
Okay,
call.
let us proceed.
Right.
But it is not here before this court till then.
Lordship inquired that how the assessing authority again passed the order. So the petitioner wrote a letter to the assistant commissioner after the Supreme Court judgment, which you lordship find at page 150,
On 50.
my lord.
Okay. After Supreme Court.
My lord. Since now, my lord, it is just now, time is 10:15.
No, let me, this para, let me complete it. It's only one. Six.
Yes.
Because 7 and conclusion I will pay for it.
Six.
Relevant provisions of VAT Act 2003 under the which reassessment was made, the Assistant Commissioner of Taxes, Tinsukia, invoked section 42 of the VAT Act 2003 for the purpose of reassessment. Hence, it is relevant to expect section 42 below for the section. So now, from a bare reading of section 42, it would appear that it has limited application. Section 42 can be invoked to correct a situation if an assessment by mistake is made under the CST Act instead of a VAT Act, or vice versa, or a court passes an order to its effect. It is difficult to comprehend that the reassessment under section 42 can be done in all such situations just to give effect to an order of the court. Moreover, the assessment for the periods mentioned above became time-barred, and as such the reassessment made was null and void ab initio. It is a subtle principle of law that those persons, this is a minor fancy part, is already. Now, conclusion. From the above discussion, I do not have any hesitation to hold that the reassessment made in 2018 by the jurisdiction assessing officer in purported exercise of powers under section 42 of the VAT Act 2003 are outside the jurisdiction, hence void and deprived of any legal effect. Further, as per the provision of section 39 of the VAT Act, the assessment after the expiry of the 5 years from the end of the assessment year becomes time-barred. The original assessment, the time-barred part, lordship may kindly consider. The original assessment made by the jurisdictional Deputy Commissioner of Taxes Tinsukia and Superintendent of Taxes Tinsukia did not allow the claim of the dealer for reimbursement of VAT under section 15B of the CST Act, and the dealer did not challenge such assessment orders passed in 2012 for the last years 2006-7 to 2008 and 9, and passed in 2015 for the assessment year 2019 9 to 10 to 13 and 14. Hence, such assessment orders passed way back had attained finality on expiry of the period of appeal or revision. The so-and-so was never a party in the so-and-so, so this is a fancy part. Therefore, appeal for these are the grounds on which it was rejected. It is there in the appeal only. But in the commissioner has no say until the refund is approved by the government. So, his letter will not give any authority otherwise.
Concluded or?
No, I will place some, their record also if possible, I can place it.
One of things, next date.
Just to clarify as to why he has passed the order, because in other cases, there are orders passed by the honorable court. Probably along with that, this particular order was passed, or if the government has authorized him, then there will be a different situation, I will place it.
One or two things my learned friend may also take instructions on next date. Lordship, section 15B, it speaks of reimbursement.
Reimbursement.
Section 50 speaks of refund.
Section,
50 speaks of refund.
yes.
There is no provision
Hmm,
under the Act for reimbursement.
Hmm.
Now, following which provision under the Assam VAT Act,
hmm,
the reimbursement of the tax for the earlier periods were granted. Not because your lordship will ultimately, when he's
Hmm.
going on,
hmm.
the things must be there, must be known. And 1 minute more, plus section 15, if your lordship reads into it,
What is the difference between refund and reimbursement?
reimbursement,
Already paid, something which is already paid
it
is to be remanded,
the person concerned.
returned.
To the person concerned, a refund is paid in excess.
Okay.
Refund is paid in excess.
There is no provision.
And lordship may kindly further see, my lord, but just giving the, my lord, when it coming, 1 minute I will take, my lord. Section 15B, it says, my lord, if somebody has paid the local taxes and sold the goods in course of interstate income and paid the taxes, then it will be reimbursed. Now, first of all, an assessment has to be made that whether he has paid the CST or not, then he has to verify subsequently that whether he has paid the local taxes or not. In the audit assessment,
2012.
the audit assessment, the question of reimbursement cannot arise because that is only for the purpose of determining the central sales tax turnover and what is the tax payable and paid or not. After completion of the audit assessment, when he finds that he has paid the central sales tax and also paid the local taxes, then only he can pass under section 15B. How he can
Okay.
pass the audit assessment?
Yes, Mr. Gugoi.
I will get that. Yes.
And about
When-
the power, I place before lordship the judgment of Supreme Court
Okay.
that when the power is not there, a specific power, then the power has to be entrusted to the whatever power is available.
Otherwise, law is there also that successor in office
He
of a
cannot-
statutory authority without any kind of fresh material cannot revisit
Enough, how it can.
an order of his predecessor.
Something I would like to clear, but to clarify.
Otherwise,
Just, when
I
we
have
are
also
discussing,
pointed out section 82, but I'm not saying that whether this order has been passed under section 82.
Then-
Because the notice and all will come.
when do you want?
Any day, convenient to.
it's better that early, my lord, so
Yes.
that
Yes,
Any day.
yes, sir. Okay.
so many days your lordship is sitting in the revision bench disposing of
Hmm.
criminal appeals.
I mean, informed I'll be sitting here at least next week. কিবা এইনাত আছে নেকি? এইটো কি? Next month. বৃহস্পতিবাৰ কি আছে? মঞ্জু পাৰা যাব। প্ৰতীক কি?
Any Tuesday or Thursday, my lord, after.
Thursday, 7-11? 7-11?
Yeah.
লিখি দিব Dr. A.K. Saraf, assisted by Mr.
Yes, sir.
B. Gogoi, Standing Counsel Finance and Taxation. Heard list the case says again on 7-11. 7-11.
You'll also get time to, my lord,
Yes, yes.
find out something more after the arguments of Mr.
Yes. Yes, yes.